This meeting is being live streamed.
Okay. Are you ready, Sarah?
Yes.
Okay. So here we go. 3, 2, and 1. Hello, and this is the time and the place for the second day of hearing on case number FDA 22-01 involving Julene Walker, the appellate, and Mapleton School District. I'm Cameron Pope, the FDAB panel chair, with the other panel members present being Dwayne Johnson and John Hartsock. Legal counsel for the panel is Jonathan Grew, Assistant Attorney General. Our court reporter today is Nagali USA. The appellate is pro se, and the school district is represented by Nancy Hungerford. The time is 9:14 a.m. and the date is August 19th, 2022. This hearing is being held virtually through the Zoom platform. This is the second day of hearing, and before beginning, the FDAB needs to put certain items on the record pertaining to exhibits and some witnesses. First, regarding exhibits, the Fair Dismissal Board has received the district's exhibits D1 through D24, and these are admitted into evidence. The FDAB has received the appellate's written opening statement, and it was received into the record. Although it is not evidence, it is a part of the record. The FDAB has also received appellate's exhibits A1 through A113. The emails following the July 13th hearing, the appellate requested the following corrections. A43, which is page 43, removing students' names. Ms. Walker, is this correct?
Yes, I found an error. I didn't want students' names in the exhibits, so I'd taken the names off of the other papers, and I just want to make sure that those were also removed for confidentiality. And okay. I also wanted to make a correction, if you don't mind. There's 133 exhibits for me.
Yep. So we're getting there. We're getting there. I promise.
I'm sorry.
Yep. Ms. Hungerford, do you have any objections to A43?
No, I do not.
Thank you. Exhibit A52, page 5, was missing in error, and now it is included. Is this correct, Ms. Walker?
Yes.
Ms. Hungerford, any objections?
Just double checking to see, this is page 2 that has now been furnished.
Page 5 is what I have for A52.
Okay, I do have that. Thank you. No objections.
Okay, thank you. A116, the appellate wishes to add the first 2 pages left out in error. Is this correct, Ms. Walker?
I'm sorry, can you repeat that again?
Yes, it is number A116. There were 2 pages that were missing, and you would, okay, that's correct?
Yes.
Thank you. Ms. Hungerford?
I have no objection. I had thought that was A117, but I see that it's A116. So we're adding 2 pages prior to the final page of the original exhibit. Is there a change in that 3rd page at all? Or is it just the 2 pages addition? Is that the cell change?
It would just be the addition of the 2 pages.
No objection.
Thank you. So now we have A1 through A33 have been admitted into evidence. So everything should be good there on the evidence. Yes, Ms. Walker.
From my understanding, the meeting is not viewable on YouTube. Just I thought I would make the technical support aware of that.
Do I need to pause for a second? Sarah?
Sorry, I didn't hear that. It is being streamed on YouTube. I can put the link in the chat. This is the same link that we had before.
Yeah, it just says it's, so the link that was sent out before, it says waiting for ODA Fair Dismissal Appeals Board. So
Maybe ask them to refresh their screen or something, because I'm watching it.
okay.
And yeah, okay. So we're going to move on into witnesses. In response to the appellate's request for subpoenas of Jody O'Mara and Brenda Moyer, the attorney for the district indicated in an email dated July 19th that she would assure the presence of Ms. O'Mara, who is the former superintendent, and ask Ms. O'Mara to check the availability of Brenda Moyer, the former principal. Ms. O'Mara then wrote an email that she, on July 19th, that she would assure the presence of Ms. Moyer to testify today. And this nullified the need for subpoenas. And now I have to ask the question, did the district secure the two witnesses?
I believe that, first of all, Ms. Mayor is on, and I think she can speak to the availability of Brenda Moyer. I have been informed that Brenda Moyer is available.
I see Ms. Moyer on here as well. So thank you. I'm just glad they're both here. Appreciate that. Okay, the appellate has indicated in an email on August 15th. At this point, she only intends to call these two witnesses. Is that still correct, Ms. Walker?
Yes, it is correct.
Thank you.
Can I ask for clarification? Does this mean that Ms. Walker will not be calling herself as a witness?
Yes, I think with the questions I'll be asking Brenda Moyer and Jody O'Mara, I didn't feel that it was necessary, and anything that I wanted to add in addition would just be in my closing argument.
Okay, thank you.
Okay, great. Here we are. So after the day of hearing on July 13th, the district indicated that it was resting its case in chief. Is the appellate ready to present her case in chief? Ms. Walker.
Can I have like 2 minutes real quick? Or maybe even a minute?
Yeah, you can have, we'll give you a minute.
Chair Pope, while we're waiting, I do have a preliminary motion that has to do with the conduct of this hearing. And I just wanted to make you aware of the fact that I do need to have that entertained by the panel prior to us beginning the actual testimony or hearing.
Okay. As soon as Ms. Walker's ready, we can go ahead with that, and then she can get started. Ms. Walker, is enough time?
Yes,
okay.
I'm good.
Ms. Hungerford has indicated that she has a motion to start this off, so we're going to go ahead and entertain that.
Okay.
Thank you. Chair Pope, last night at 10 o'clock, after I finished another school board meeting, I looked at my email and I became aware of the fact that during the day, Oregon Department of Education had sent out to all fair dismissal panel members the entire list, including the 3 who are here present today, a set of over 100 pages of anti-vaccination information. This was not furnished by Ms. Walker. I don't know that she's aware of it. It was furnished by a representative of a teacher who has another case that's going to be heard on September 30th. And had that representative had asked that
the material be sent out to all fair dismissal panel members, all 17 or 24, I guess. There may not be all 24 appointed now. From what I could tell, that did happen. And so I believe these panel members have all been furnished copies of this 100 some pages of anti-vaccination material. I object to this, and I ask that you provide a directive to these panel members that they not open or that they delete and destroy all of that material that was sent out. I believe it is improper and unprecedented for the Fair Dismissal Board or the Oregon Department of Education to send out material to all fair dismissal panel members solely upon the request of a private citizen. This is not an attorney, but if in any case, has nothing to do with this case. But that material was apparently sent out to the 3 panel members here. And I would like a directive that they destroy and not disregard, if they've already opened, all of that information.
Okay, so this is the FDAB panel. In this case is only taking evidence that are on the record. If it is not in the record, we are not going to be using that as evidence to make our decision. And we would like that on the record, that anything outside of what is in evidence and on the record is not in our decision-making power.
I repeat, though, that I would like to have the panel instruct each other, or to have your administrative law judge instruct you that that material should be destroyed. And therefore, there would be no question about whether you review that material now, whether you reviewed it yesterday, I can't help, but that you would not review it at any time after this hearing before you make your decision.
We can do that. So I can, on the record, say that the panel members are instructed to delete that email, and it will not be affecting our decision in this case.
Thank you.
Okay. Moving forward. So Ms. Walker, if you are ready to present your case, you may call your first witness to direct examine.
Okay, I'd like to first do my direct examination of Brenda Moyer.
Okay. And I see Brenda is on. Hi, Brenda. I need to do an oath. So we're going to go ahead and do that right now. Can you please state your full name and spell your last name?
Brenda Moyer, M-O-Y-E-R.
Thank you. Can you please raise your right hand? Under penalty of perjury, do you solemnly swear or affirm that the evidence you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. I need to remind you that your testimony is being recorded. It is therefore important that you give audible responses that are clear, such as yes and no, rather than slang or nodding of the head.
Yes.
Thank you. Ms. Walker, this is your witness.
Thank you. Hi, Brenda.
Hello.
Oh, I'm just going to get right to it. So how long have you known me?
Most of your life. My first official remembrance is that I was your 4th grade teacher. And then in subsequent years, you've been involved in our community, and I was your advising principal, your principal the last few years.
Thank you. How long were you my direct supervisor?
For the entire time you've been back at Mapleton. So I didn't look at the exact number of years, but since your employment back.
Okay, so so last year would have been my 5th year.
Okay.
Is that correct?
If you say so, I know it's been at least 4.
Okay. Where would the teachers you supervise look in order to find the teaching duties they should be fulfilling?
There's a variety of places, but we do give out a teacher's handbook every year. And then there's obviously just making sure you keep your license, and those sorts of things are required.
Okay. Where would the teachers you supervise look in order to find teaching standards of performance they should be meeting?
So depending on the curriculum that they teach, but ODE provides those on their website. So that's where they go to the standards.
Okay. How do teachers know whether they are fulfilling their teaching duties and meeting the teaching standards of performance?
So we have an evaluation process, and there are goal setting, and it's both student-centered as well as professional goals. And we meet formally 3 times a year, but throughout the year we meet to discuss those performances.
I'd like to have you turn to page exhibit A 124.
Okay.
So do you remember completing these performance evaluations for the 2017, 2018, and the 2018 and 2019 school years?
Yes.
Would you like to take a little bit of time just to kind of like go through them briefly, just to kind of remind yourself of the scores? I mean, you don't have to read everything in detail. The parts I would like you to focus on are where it talks about calculating summative teacher evaluation, where you gave me scores on the different effectiveness domains, such as planning and preparation, classroom management, delivery of instruction, monitoring, assessment and follow-up, family and community outreach, and professional responsibilities. Those are kind of the main, that page for the first evaluation and that page for the second evaluation are the two that would like you to review, if you don't mind.
Okay, I'm ready.
Okay. Do you believe you evaluated me fairly and truthfully in these 2 performance evaluations for those 2 school years?
Yes.
Okay, now I'd like you to go to exhibit A43.
Okay.
Okay, so this is my defense against termination recommendation that I sent to the school board prior to my hearing on April 20th. Have you read the 28-page defense against termination recommendation with the accompanying 31 exhibits that I submitted to the school board 8 days prior to the April 20th hearing?
I have not.
Okay.
I received this booklet yesterday.
Yeah, I kind of figured, so that's okay. So I'm going to direct you to page 20 in that document.
Okay.
So I went through and I calculated the average score, cumulative score for the first year and second year that you evaluated me. So based on the average score I received from the scores you gave me for all of the 6 domains and my 2 student learning goals for the 2017-2018 school year, which was a 3.25 out of 4, which was 81% overall effectiveness. How would you rate my overall teaching performance that year from the following options? 1, does not meet standard. 2, improvement necessary. 3, effective, or 4, highly effective?
4, highly effective.
And will you please now turn to page 21 and 22 of this defense against termination recommendation?
Yes.
Based on the average score I received from the scores you gave me for all of the 6 domains and my 2 student learning goals for the 2018-2019 school year, which is a 3.75 out of 4, which would be a 94% overall effectiveness. How would you rate my overall teaching performance for that year from the following options? 1, does not meet standard. 2, improvement necessary. 3, effective, or 4, highly effective.
Highly effective.
If you turn to page 22, if you look down to the middle of page 22, it states that during the 2019-2020 school year, the Mapleton Educators Association and the district decided that because of the challenges presented by COVID-19, there would be no teacher evaluations that school year. Is that correct?
It wasn't a formal decision, but you're right, we did not evaluate those 2 years.
Okay. To your knowledge, did I do anything during the 2019-2020 school year that you would classify as insubordinate, neglectful of my duties, grossly neglectful of my duties, or make me grossly unfit to perform my duties?
During what time period?
During the 2019-2020 school year. So that would be my 3rd year teaching.
No, you did not.
To your knowledge, did I do anything the 2019-2020 school year, so the same school year, that would give you reason to believe that the TSPC should revoke my teaching license?
No.
During the 2020 and 2021 school year, the Mapleton Educators Association and the district decided that because of the challenges presented by COVID-19, there would be no teacher evaluations that school year. Is that correct?
We did not evaluate those years.
Were you aware at the beginning of the school year, that 4th year, and despite it not being an expectation of you as my direct supervisor, I still set 3 professional goals. The first, to increase student confidence in their Spanish speaking ability. The second, to increase student learning in business management. And the third, to increase student learning in Spanish 1. Were you aware of that?
Yes, you and I had a conversation.
Were you aware that for every student that remained in these 3 classes until the end of the school year, with the exception of 1 student who was given an incomplete to complete work in the summer, all 3 of these goals were met by the students?
I was not aware formally that I can remember, but I would believe you 100%.
Do you think that the marks you gave me on my performance evaluations and the meeting of my professional goals over the course of my teaching at Mapleton would be a demonstration of my competency, ethics, and professionalism?
Yes, for the categories that we evaluated, absolutely.
To your knowledge, did I do anything during the 2020-21 school year, so that would be my 4th year teaching, that you would classify as insubordinate, neglectful of my duties, grossly neglectful of my duties, or make me grossly unfit to perform my duties?
No.
To your knowledge, did I do anything during the 2020-21 school year that would give you reason to believe that the TSPC should revoke my teaching license?
No.
So now if we go back to page 15 of the same exhibit, you'll see kind of about just halfway down the page, I start to include different contributions with asterisks by them. So these are 17 different contributions. Do you believe these? And so they go on to page, so it's 15, 16, and then on to page 17.
Yes.
Do you, just kind of at a quick glance, do you believe that any of those contributions are untrue? Like, would you say that all those things that I've said I've done?
I'd like to ask that the witness be given an opportunity to review those.
Yes, of course.
I believe them all to be true.
Would you agree that these 17 different contributions would be a demonstration of my competency, ethics, and professionalism?
Yes.
Okay. Now I'd like to have you turn to page exhibit 104.
Excuse me, is this page 104 within this same exhibit?
No, I'm sorry, forgive me. It's exhibit 104. So I'm moving out away from exhibit A43. We're now moving into A104.
Thank you.
You're welcome. Okay, do you agree that I was asked by the graduating class to be the guest speaker at Mapleton's 2022 graduation on Saturday, June 11th?
Yes.
Do you have any regrets about allowing me to speak at Mapleton's 2022 graduation on Saturday, June 11th?
No.
As the principal of Mapleton High School, why did you still allow me to speak at the graduation ceremony, even though the school board had voted to terminate my contract with the district on April 20th, 2022?
The guest speaker is frequently not an employee, so it's certainly not a requirement that they be currently employed. And the guest speaker, by and large, is a decision by the class, and the students absolutely wanted you to speak for them and to them at graduation. So it was a student decision I supported.
Are there any teaching duties outlined by law, the Mapleton School District policy, TSPC rules, the collective bargaining agreement, or my June 15th, 2022 contract with the district that you believe I have failed to perform?
In terms of your teaching and academics, no. But when you left the district, you were no longer, and my understanding is no longer able to continue doing those. And so in terms of what you have performed during your performance, absolutely you were outstanding.
Okay, thank you. During COVID, when the Mapleton School District was doing comprehensive distance learning, did you have any concerns or receive any complaints about my individual performance teaching my courses remotely?
No.
When we moved to limited in-person instruction, and I volunteered to be one of the teachers who provided in-person support to the students while we were still unable to provide in-person instruction for the entire school day, did you ever find that I refused to follow any of the safety protocols or for limited in-person instruction?
No.
Did you ever find that I refused to wear a mask?
No.
Did you ever find that I refused to fill out and complete the daily contact tracing logs?
No.
Did you find that I followed every other safety protocol?
Yes, you did.
During limited in-person instruction, did you get any complaints that I was refusing to follow any of the safety protocols for limited in-person instruction?
No.
When the entire district moved to in-person instruction for the spring semester in 2021, did you ever have any complaints that I was refusing to either wear a mask, fill out and complete a daily contact tracing log, or follow any of the safety protocols?
No.
In your opinion, did you find that during the COVID-19 pandemic, I was cooperative in adhering to the safety protocols as they changed over time for the district?
Up until the time that, up until October 18th, yes.
During the time that contact tracing logs were required for tracing COVID, how would you describe my adherence to completing those logs and turning them in daily?
Extremely accurate and on time, and they were very professionally and adequately done, for sure.
Can you think of any instance where I think we've established that. So you've already testified that I've never refused to wear a mask. Can you think of any instance where I refused to wear 2 masks in my role as a teacher when asked to do so?
No.
Do you remember the condition of the staff supply closet at the beginning of last school year before I was asked to organize it on October 18th, 2021?
Yes.
If you had to describe the staff supply closet at the beginning of that school year, would you describe it as extremely organized or extremely disorganized?
Extremely disorganized.
Were you aware that Superintendent O'Mara asked me to organize the staff supply closet on October 18th, 2021?
Yes.
And if you turn to Exhibit 105, you'll see a picture, 2 pages of pictures that I took after I organized the supply closet.
Yes.
Based on this photo, how would you describe the state of the high school closet after I spent the school day organizing the closet?
Extremely organized.
Okay. Over the course of the school day on October 18th, while organizing the high school supply closet, did you ever hear me complain or have a disrespectful attitude while organizing the high school closet?
No.
To your knowledge, would you say that up through October 18th, 2021, I submitted to your authority and Superintendent O'Mara's authority?
Excuse me, was this after October 18th you're asking about?
No, this is the time up through October 18th.
Through October 18th.
Yes.
All right.
Mhm. So I'll repeat that question, Brenda. To your knowledge, would you say that up through October 18th, 2021, I submitted to your authority and Superintendent O'Mara's authority?
Yes.
To your knowledge, would you say that up through October 18th, 2021, I was both willing and able to perform any tasks related to my teaching duties?
Yes.
So now we're going to go to Exhibit A24.
A24.
Yes, A24.
Hold on just a minute.
And this is the next set of questions will be related to this exhibit, A24. These are
Miss Locker, Miss Hungerford asked for a minute, so let's just wait 1 second till we can all flip through the book.
okay. I apologize. Sorry.
Turning
No worries.
this is a bit difficult. Thank you very much, Chair. Okay, I'm there now.
Okay, thank you.
The next set of questions will be related to this exhibit A24. These are OAR 584-020-000 through OAR 584-0202-0045. Unless, actually, I think I might have, that's a typo. It should be the last one, OAR 584-020-0045. These are the standards for competent and ethical performance of Oregon educators. They were set by the Teacher Standards and Practices Commission. How familiar are you with the rules contained within this document?
Somewhat. I haven't memorized them, but I know I use it as a reference. So, yes.
Okay. On page 2, if you turn to page 2, the TSPC has defined competent in OAR 584-020-0010 as discharging required duties as set forth in these rules. Do you agree with the TSPC's definition of competent?
I'm going to raise an objection at this point about questions regarding competence. The district did not charge this teacher with inadequate performance. So the district did not base its dismissal decision upon lack of competence, as that term is defined in the statutes and these rules.
Okay.
So response.
So I will move on to the next set of questions then, relating to ethics.
Okay.
Let's see here. So on page 2, again, the TSPC defines ethical as conforming to the professional standards of conduct set forth in these rules. Brenda, do you agree with the TSPC's definition of ethical?
Again, I'll object. I'm not sure that any individual has the authority or the ability to disagree with rules. The rules are the rules, and they are adopted through a rulemaking procedure. So this witness's agreement or disagreement is not relevant to this case.
Okay. I will ask her the next question.
Okay.
So the definition that the TSPC provides states that ethical is conforming to the professional standards of conduct set forth in these rules. Brenda, do you believe that these rules, that quote, these rules stated in this definition refers to the TSPC rules outlined in the TSPC rules or some other rules outlined by a different administrative agency?
Well, the term "these rules" would indicate it was this set of rules.
Okay. And then if you turn to page 7 of that same exhibit, TSPC further defines the ethical educator OAR 584-020-0035 as a person who accepts the requirements of membership in the teaching profession and acts at all times in ethical ways. In so doing, the ethical educator considers the needs of the students, the district, and the profession. This rule also outlines the requirements of membership in the teaching profession by listing the obligations of the ethical educator to the students, the district, and the profession. These obligations are outlined on page 7 and 8. Can you please take a moment and look through them?
Yes.
Okay. In your observations of me as my direct supervisor, did you find that I have failed to fulfill any of the obligations required of the ethical educator listed in this section of the TSPC rules?
Prior to October 18th? No.
On page 8 is OAR 584-020-0040, which outlines TSPC's grounds for disciplinary action. These grounds are divided into 6 different sections, sections 1 through 6. Section 1 of the grounds for discipline start on page 8 and ends on page 11. This section lists several crimes from ORS 342.143 for which a teacher can have their license denied or revoked. To your knowledge, have you found that I met any of the grounds for disciplinary action by committing any of the crimes outlined in section number 1, pages 8 through 11?
Prior to October 18th, no.
Okay, have you found that I've committed any of those crimes after October 18th?
I'm going to object to this line of questioning, given the fact that under the statute, there is no role for a school principal to make any judgments or make any recommendations to the school board. That is the job of the superintendent by law. So I believe it's really immaterial
that what this witness's opinions might be or interpretations. She did indicate that she was roughly familiar with this material, but she had no role in the decision making.
But I would argue that as my direct supervisor, she should have the best understanding of my performance and my ethics and my professionalism. And because those are the things that are challenged in the 20-day notice, I should be able to ask questions along these lines.
So I'm going to go ahead and overrule the objection, and Ms. Walker, you can continue with these questions. I want to make sure you have a moment to state your case before this panel. You can continue with those questions.
Thank you. Section number 2 is on page 11. The TSPC states that an appellant or that an applicant fails to meet the requirement of ORS 342.143, good moral character, if the applicant engages in gross neglect of duty, gross unfitness, in violation of section 4 of this rule, or other acts which are in violation of sections 1 and 3 of this rule. Before moving on to the remaining sections, would you describe me as an educator with good moral character?
Yes.
Section 3 is also on page 11. It states, the commission may initiate proceedings to suspend or revoke the license or registration of an educator under ORS 342.175, or deny a license or registration to an applicant under ORS 342.143 who does anything listed in letters A through E. Since I'll later be asking you questions specifically related to C and D, can you please look at A, B, and E of section 3?
Yes.
In reference to grounds A of section 3, to your knowledge, have I ever been convicted of a crime not listed in section 1 of this rule, in which the TSPC could find that the nature of the acts constituting the crime for which the educator was convicted render the educator unfit to hold a license?
No.
In reference to grounds B of section 3, to your knowledge, have I ever been charged with knowingly making any false statement in the application for a license or registration?
No.
In reference to grounds E of section 3, to your knowledge, have I ever been convicted of a crime involving the illegal use, sale, or possession of controlled substances?
No.
Okay, now we're going to look at the grounds of gross neglect of duty and gross unfitness by looking at sections 5 and 6, respectively. And by 5 and 6, I think I mean 4 and 5. At the bottom of page 11, the TSPC states, gross neglect of duty is any serious and material inattention to or breach of professional responsibilities. And through the end of page 12, provides a list of actions that may be admissible as evidence of gross neglect of duty, which are sections A through S. This list includes, among other things, actions involving violence, sexual conduct with students, and appearing on duty or at any district-sponsored activity while under the influence of alcohol or any controlled substance. Could you please take some time to review these actions?
Yes.
To your knowledge, have I ever committed any of these actions listed as A through S that would be admissible as evidence for gross neglect of duty?
Prior to October 18th, no.
After October 18th, have you heard of me doing any of those things?
I am not in charge of licensure for the district, as that was stated by our attorneys, that is a superintendent. And so I wasn't privy to all the information about what it would take to continue teaching after October 18th in the same way that Jody O'Mara was. But my understanding was that if teachers refuse to either become vaccinated or follow one of the two exceptions, that they would no longer be allowed to teach. So as we look at Item R, knowingly worked without a license. You weren't there, but had you continued, the district my understanding is the district said you need to follow the directions and you refused to follow the directives from the state.
Okay, so we're going to go on to specifically, if you look at one of the things on the list, item J, it says resignation from a contract in violation of ORS 342.553. To your knowledge, have I ever resigned from a contract in violation of ORS 342.553?
No.
And then looking down at item 0, or not 0, O, has my behavior as a teacher ever proven to be a substantial deviation from professional standards of ethics set forth in OAR 584-020-0035, which we discussed earlier?
Not in my observations, no.
To your knowledge, have I performed any of the acts listed in A through S as evidence for gross neglect of duty?
No.
Can you think of any other action I have taken that the TSPC could possibly consider gross neglect of duty?
No.
Which of the above acts? Okay, never mind. We're going to move on. So now at the top of page 13, the TSPC describes gross unfitness as any conduct which renders an educator unqualified to perform his or her professional duties. Conduct constituting gross unfitness may include conduct occurring outside of the school hours or off school premises when such conduct bears a demonstrable relationship to the educator's ability to fulfill professional responsibilities effectively. The following may be admissible as evidence of gross unfitness. Consideration may include, but is not limited to, sections A through F. When I read these examples of gross unfitness, can you please state yes or no as to whether I have committed any of these actions to your knowledge? Okay. A, revocation, suspension, or denial of a license by any other state for reasons through and procedures that are in the same as or substantially equivalent to those permitting similar action in Oregon.
No.
Fraud or misrepresentation.
No.
Conviction of violating any federal, state, or local law. A conviction includes any final judgment of conviction by a court, whether as a result of guilty plea, no contest plea, or any other means.
No.
Commission of an act listed in OAR 584-0040, section 1.
I would ask that you give her the opportunity to inspect that section if you're going to ask her to answer that question.
Yes, definitely. So that would be, let me see if I can get the page number for you. So that would be starting on page 8. And it's under the grounds for disciplinary action.
No.
Okay. Admission of or engaging in acts constituting criminal conduct, even in the absence of a conviction.
No.
And then F, violation of a term of probation imposed by a court.
Not that I'm aware of, no.
Can you think of any other action I have taken that the TSPC could possibly consider gross unfitness?
No.
Which of the above sections listed in A through F with the action I took most, oh, never mind. I don't need to ask that question. Okay, now I would like to have us turn to Exhibit A26. So this is the TSPC professional teaching license. Do you agree with the TSPC OAR 584-210-0040 that the professional teaching license signifies that the educator is an experienced teacher who has successfully demonstrated an advanced level of educator knowledge, skills, and dispositions?
Again, I would object that asking this witness as to whether or not she agrees with a standard is completely irrelevant. The standard is as it is. Whether she thinks it's an appropriate standard or not really is not a matter for any relevance in this hearing.
Okay. I have held a professional teaching license from the TSPC since November 15th, 2015. Based on your experience as my direct supervisor at Mapleton, do you believe the TSPC was justified in issuing me a professional teaching license on that date?
Yes.
Do you believe that the TSPC would still be justified today in allowing me to retain my professional teaching license?
I can't make that call because I don't know what all the criteria is they use.
Are you able to cite any TSPC rule to your knowledge governing the behavior of contract teachers that I have violated?
TSPC, no.
Okay.
Again, that I'd like to clarify that I am not the superintendent and I don't have all of the information from ODE on ongoing. These documents were clearly written before a world pandemic, and I know that mandates and rules changed. And I did not have as much access to that changing information as Jody O'Mara as our superintendent.
Thank you. During your time as my direct supervisor, did you ever find me to be insubordinate?
No.
During your time as my direct supervisor, did you ever see me being defiant to my authorities in the district?
No.
During your time as my direct supervisor, did you ever see me being disrespectful to my superiors?
No.
Would you describe me as cooperative, respectful, and generally submissive to authorities in the district?
Yes.
Have you ever been reticent to give me directives because you thought I would be disrespectful, defiant, hostile, or thought I would complain?
No.
Have you ever received complaints from students, parents, or other staff that I had been disrespectful to them?
No.
During your time as my direct supervisor, did you ever find me to be neglectful of my teaching duties?
Never.
During your time as my direct supervisor, did you ever have to refer me for disciplinary procedures or warn me that I was treading closely to being disciplined?
No.
Did you ever place any notes, memos, or other documentation in my personnel file concerning issues where I was insubordinate or neglectful of my professional or contractual duties?
No.
Okay, that's it. So I thank you very much for taking the time to answer my questions.
Absolutely.
Ms. Hungerford?
I have no cross-examination for this witness.
Okay, so at this point, it looks like we are finished with Ms. Moyer. Thank you for your time. And with that, I believe it is probably best in all of our interests to take a quick break before we jump into our next witness. So the time is currently 10:06, and we will reconvene here at 10:15. So 9 minutes from now, we will see you back here. Thank you.
Thank you. Hi, I'm in the middle of their dismissal. Jody, can you hear me? Hi, this is Nancy. Yeah. I just want to remind you that one, in your letter, you say that each and every one of those is separate and sufficient reason. The PSPC rule violations, I never advised you to use the reason that PSPC never gets around to deciding that the months and years that sometimes happen. So have you ever received any indication PSPC has drawn the conclusion that she was not in violation of any of the rules? Okay, so as far as you know, yeah, that's just where you definitely get no update on their exposure. Right, yeah, it's the first two, yeah, it's insubordination and it's collective duty. I didn't hear anything there that's detrimental, really, it's just like, this is giving our wheels on some big, some matter that frankly, I don't even believe belongs in person to them, but that's my own opinion, and not the opinion of your attorney, so, after this, I will consult with them, but it's not good, I think. Okay, good. All right. Then bye.
All right, it is 10:15, and we are going to go back on the record at this time. Ms. Walker, are you available? Are you here?
Yes.
Awesome, thank you. Good to see you. This time, you can call your next witness.
I'd like to do my direct examination of Jody O'Mara.
Okay. So Ms. O'Mara, you were sworn in at the last day of this, and so you are still under oath. And I would just like to remind you that we are that you are still under oath from that day. So at this point, we may continue.
All right. 1 second. Okay. Hi, Jody.
Hi.
As you previously testified on July 13th, 2022, my employment with the district began in the fall of the 2017-2018 school year, and my last contract with the district was signed on June 15th, 2021. Is that correct?
Yes.
There's a little bit of a delay, so we'll just try to factor that in as we go. Do you sign employment contracts with the Mapleton School District?
Yes.
And obviously, I'm going to be asking these questions as if you were still the superintendent. So I understand that you're retired, but yeah, at the time of our interactions, you are the superintendent. So I'd like to now turn to Exhibit A2, which is the June 15th contract between Mapleton School District number 32 and me, Julian Walker. Did you sign the most recent employment contract between me and the district?
Yes.
In term number 1 of my June 15th contract with the district, it states the following: the teacher shall perform assigned duties in the schools and the school district for the period indicated below. Job performance shall emphasize teacher accountability and student achievement. What documents or guidelines would a contract teacher look to in identifying her duties under this employment contract?
You would look at TSPC, ethical educator, ODE standards for professional practice, and for specific to the district, the staff handbook.
Okay. Under this contract, would the contract teacher who assigned this contract be obligated to fulfill the duties assigned to her under the collective bargaining agreement, which governs this contract?
Yes.
What about the district? How does the district identify its duties under the employment contract?
Are we referring to the collective bargaining agreement?
I'm referring to the contractual duties that Jody signed on the June 15th contract.
Thank you.
So can you repeat the question?
Yeah. How does the district identify its duties under the employment contract?
I guess I don't understand the question.
So like when there's a contract, there's two parties that are just saying, I will do this and you will do this. So you've mentioned that I would know what my duties are by going to the PSPC standards and so forth. How would the district identify its duties under the employment contract? Like what document would it go to know what its duties are?
Well, the district uses Division 22 standards. The district uses the same ODE standards as well as collective bargaining agreement.
Okay. Have you read the collective bargaining agreement?
Yes.
Are you aware that the Oregon revised statutes place specific duties on superintendents in regard to contract teachers?
Yes.
Would you agree that evidence of the existence of a contract being in effect would be that both of the parties to the contract were performing their contractual duties?
Again, I'm going to be asking for clarification and raising an objection to any assertion here that there's a violation of the collective bargaining agreement. That matter is governed by the grievance procedure in that collective bargaining agreement. And ultimately, any grievance that would be established would have to be proceeded and processed rather by the association to arbitration. Therefore, this panel is not an authority or has ability to determine whether or not there's been a violation of the collective bargaining agreement.
Yeah, so we do not have that authority. And so if you could make sure you phrase your questions, that we are not going to be discussing the CBA at this panel.
So right now my questions are related to the two parties demonstrating that they're fulfilling their contractual duties. Because if one of the parties is not fulfilling their contract, then that could be evidence that there was a termination. And since this is the Fair Dismissal Appeals Board panel, I think these questions related to the contract are definitely probative to this case.
So not the collective bargaining agreement contract. That is not our jurisdiction.
So, okay, I'll do my best to keep asking the questions related to the contract. So.
Again, are you referring to the individual contract?
Yeah, so I signed this contract on behalf of myself. So I'm so I agreed to do these things, and Superintendent O'Mara signed this contract on behalf of the district, saying that that she, representing the district, would do these things. So my questions are related to, was the district performing its contractual duties to me during my employment?
I do not have an objection to that, except as if this, Ms. Walker is asking for an interpretation of or asking to respond to questions about whether a collective bargaining agreement was violated.
Okay, so just for the record, we are not looking at the collective bargaining agreement. However, we will be, Ms. Walker is presenting her contract with the district, not collective bargaining.
Thank you.
Okay, you may continue, Ms. Walker.
So my question is, would you agree that evidence of the existence of a contract being in effect would be that both of the parties to the contract were performing their contractual duties?
Yes.
Would you agree that when none of the duties imposed by the contract are being performed, the contract has possibly been terminated?
Can you say that?
That calls for a legal determination, which is superintendent, ex-superintendent is not one that would be authorized for her to make without advice of counsel.
Then my next question, if the boss on a construction site told an employee to go home, to not return to the work site, and that his pay was ended, would that employee be wrong to tell his wife that he was fired that day, even if the boss never used that word?
I'm going to object to a theoretical question that doesn't have any application to this case.
That's going to be sustained. Let's go to the next question.
Okay. Exhibit A3, I'd like to have us turn to A3. This is the accountability for schools for the 21st century law. Have you read ORS 342.805 through ORS 342.9375, also known as the accountability for schools for the 21st century law?
Not for quite a while.
When was the last time that you recall reading the document?
I referenced the document as needed, but reading it in full, I don't know. I really don't know.
Okay. On October 19th, 2021, was I employed by the district under contract?
Yes.
When did, let's see, when did my employment with the district end?
After the board voted to approve my recommendation for terminating 22 board meeting.
Okay. Would you mind repeating that last comment because you cut out?
Sorry.
It's okay.
Your employment was terminated after the board approved my motion to terminate your employment at the April 2022 school board meeting.
Okay. Between October 19th, 2021 and April 21st, 2022, was I employed under contract with the district?
You were technically employed on unpaid leave, yes.
Which of the district's contractual or legal duties towards me were being performed from October 19th, 2021 until April 21st, 2022?
You repeat the question. I don't think I understand it.
Okay. Which of the district's contractual or legal duties towards me were being performed from October 19th, 2021 until April 21st, 2022?
I don't know. I guess I don't understand the question.
So in the June 15th contract, there are things that I signed that I would do in the contract.
Mm-hmm.
There are things that you signed that the district would do when you sign the contract. So there are things like, you know, I agreed to perform all my assigned duties in the schools of the school district, whereas the district agreed to pay me for fulfilling, you know, my duties. So there's certain things that the district said that they would do in this contract. And again, this is A2 if you wanted to refer back to it. So my question is, which of the district's contractual or legal duties towards me were being performed from October 19th, 2021 until April 21st, 2022?
Being paid.
You know, I'm going to raise an objection to this line of questioning that the Fair Dismissal Board is responsible for interpreting and applying the law. The law gives the district the ability to dismiss the contract teacher. In terms of this individual employment agreement, I don't believe that Fair Dismissal Appeals Board has a status to decide that issue.
I'm going to overrule that. I think Ms. Walker is just stating her case and making sure that everything was followed. And so I'm gonna allow this line of questioning to continue. Miss O'Mara, you're breaking up really bad at this time. And I don't know, maybe it's a question for our court reporter. Is it okay if she turns off her camera to help with connectivity?
That's fine with me.
Okay. Is that okay with you, Ms. Walker?
Yeah, that's fine.
Okay, maybe that'll help so that we're clear. And then again, Miss American, or actually probably Miss Walker, we asked that question again. We were not able to hear Miss O'Mara's answer.
Okay, thank you. Which of the district's contractual or legal duties towards me were being performed from October 19th, 2021 until April 21st, 2022?
So to my recollection, none. You were on unpaid leave.
Was the district providing me with any salary or benefits from October 19th, 2021 until April 21st, 2022?
No.
I'd like us to now turn to Exhibit A14. So this is part of the collective bargaining agreement. I'm not asking the Fair Dismissal Appeals Board to make any determination on whether my grievance on my grievances themselves. I'm asking these questions in order to show whether or not the district was treating me as an employee or a non-employee. So if they were treating me as a non-employee, then they would have no obligation to follow the collective bargaining agreement. But if they were treating me as an employee, then they would have an obligation to follow the collective bargaining agreement.
I have the same objection as before. This panel is not authorized to make those determinations about the interpretation of a collective bargaining agreement.
And that's sustained. So this is not a question about the CBA.
Okay. So why was I not paid during my suspension from October 19th, 2021 until the termination of the contract on April 20th or April 21st, 2022?
Employees who refused to follow the governor regarding vaccine for COVID-19 we were not able to.
Could you please repeat that? You cut out again. Sorry.
Sorry, I don't know what's wrong with my internet. After October to employ any receive a vaccine who did not either take the vaccine or religious medical exception.
It's really a bad connection. Could I suggest maybe writing your answers in the chat? Would that work? It's better than nothing.
What if she were to get on with a telephone connection as opposed to this internet connection?
Okay.
Sorry, I'm isolated in my.
Are you, Miss O'Mara, are you able to call in to this recording through your cell phone?
Yes.
Okay. We will pause until Miss O'Mara can do that, and that way we can hear her better. Thank you. Sorry about that. Sarah, do you have the phone number, or can you make sure Miss O'Mara gets the phone number to call in?
You bet. Yes, I can.
Thank you.
Did you want to take a break and I'll put up the slide until I get Jody on the phone?
Yeah, why don't we go ahead and do that? We will pause the record for, let's say just 3 minutes. Maybe we can get done in 3 minutes, and we'll check back in at 10:37.
Okay.
What am I on?
Josie Lee's phone, can you hear me?
Yes, can you hear me?
Yes, and there's an echo, I believe, because you're still connected through your computer.
Yeah,
If you
I
could-
just took it off.
Perfect. Okay, that sounds a lot better so far.
My apologies to the panel.
It's not your fault.
Okay, it looks like the panel has returned. Ms. Walker.
Yes, I'm here.
Awesome. It looks like we got this going again. We will go back on the record. Thank you for that. And thank you, Ms. O'Mara, for working through this. So we will continue. Ms. Walker, can you ask the last question again, and we'll pick up from there.
Let's see. So the question was, why was I not paid during my suspension from October 19th, 2021 until the termination of the contract on April 21st, 2022?
You were put on unpaid leave because according to the governor's mandate, school districts could not employ staff that were not either fully vaccinated and or had filed a medical or religious exception. And so you were placed on unpaid leave pending your termination.
I'd like to go back to Exhibit A3. Again, this is the accountability for schools for the 21st century. If you could turn to 342.875, suspension and reinstatement. That is on page 6 of that exhibit. And I will read that. It says, whenever a district superintendent has reason to believe that cause exists for the dismissal of a contract teacher on any ground specified in ORS 342.865 1B to F, and when the district superintendent is of the opinion that immediate suspension of the teacher is necessary for the best interest of the education in the district superintendent may suspend a contract teacher from the position without prior notice to the teacher. The teacher's salary shall continue during the first 5 days of the suspension period. However, within the 5 days after the suspension becomes effective, either the procedure shall be commenced for the dismissal of the teacher pursuant to the provisions of ORS 342.805 to 342.937, or the teacher must be reinstated. Are you testifying that when you unilaterally prohibited me from continuing my teaching duties, listed my teaching position as being open for hiring, and stopped all of my pay and benefits, that it was not a suspension?
I guess I'm confused by the question, whether it was a suspension or unpaid leave pending dismissal.
So I'll repeat the question. Are you testifying that when you unilaterally prohibited me from continuing my teaching duties, listed my teaching position as being open for hiring, and stopped all of my pay and benefits, that it was not a suspension?
No, you were suspended.
Okay, so I was suspended. So what law, district policy, or section of the collective bargaining agreement permits the superintendent to place a contract teacher on suspension without being paid during that suspension?
I'm going to object to a question that calls for legal information. I mean, this superintendent is not an attorney in the state of Oregon, and has testified she was under the advice of attorneys. So for her to be able to cite specific laws, I would indicate is not particularly a probative question here.
I would like to challenge that by stating that these are the Oregon statutes that were provided to me by Superintendent O'Mara when she dismissed me. And she said that she has made reference to them. And these are actually the laws that govern her treatment of me as a contract teacher. So I think it would be fair to ask why she did not follow this statute to pay me during the time of my suspension.
So that was not the question. So I'm going to sustain the objection on the question that you asked. If you need to reword the question to make it so that it is proper, then you can go ahead and do that, but we will sustain the objection to that question.
Okay, so my question, I'll rephrase it. So pursuant to 342.875 related to suspension and reinstatement, my question is, why was I not paid during the time of my suspension as outlined in this particular statute?
That was based on advice of legal counsel, based on the governor's mandate regarding the vaccine.
Is that also why I was not reinstated into my teaching position as well, pursuant to ORS 342.875?
Yes, failure to comply with the vaccine mandate and upon advice of legal counsel.
Okay. So I'll now move on to Exhibit A51. I'm just for Ms. Hungerford to locate that exhibit.
Yes, I have it in front of me now. It just takes a little while to turn the pages in the notebook.
Sorry. I tried to add those dividers to make it better, but I don't know how much that actually helped.
That helps. It does.
Okay. In your presentation to the school board during my hearing in executive session on April 20th, 2022, you said that you did not move for immediate dismissal back in October. Is that a violation of OAR 333-019 1030 section 3B, which states that after October 18th, 2022, a school may not employ teachers at school unless the teachers are fully vaccinated against COVID-19 or have an approved or accepted medical or religious exception.
Yes.
Okay. So how do you explain your failure to comply with OAR 333-019-1030, seeing that you recommended that I be dismissed for not complying with that same administrative rule?
Well, the reason are you asking why I didn't immediately go for dismissal?
Yes.
I was hoping that by giving time to determine if the vaccine mandate would become a permanent rule or not, and more information to be gathered by both you and the district regarding the vaccine, that maybe the circumstances around your unpaid leave would have changed.
Okay. As of October 31st, 2021, was the district in compliance with OAR 333-019 1033B?
I
And
don't know what
that is a legal conclusion.
So I believe that is, if we want to turn to exhibit, let me check here. I just want to pull up that ruling real quick. If you go to exhibit A82, this is an email that you sent out with a number of different attachments, the OAR that we're referring to, the religious exemption form, the medical exemption form, the vaccine facts from OHA, and then the PowerPoint that you sent out on August 31st after the staff meeting. So if you go to the first attachment there, it's the OAR. And then you go to OAR 333-019 1033B.
What subsection is being referred to here? You referred to B, but I'm not sure which subsection 1, 2, 3, et cetera, et cetera.
Oh yeah, so it would be section 3B. So the first part is talking about the compliance of the teachers to not teach, work, learn, study, assist, or observe. But then part B is addressing the compliance of the district, which states a school may not employ, contract with, or accept the volunteer services of teachers, school staff, or volunteers who are teaching, working, learning, studying, assisting, observing, or volunteering at a school unless the teachers or school staff are fully vaccinated against COVID-19 or have a documented medical or religious exemption. And that applies after October 18th, 2021. So my question again was, as of October 31st, so at the end of that month, was the district in compliance with OAR 333-019 1033B?
Same objection, cause for a legal conclusion.
So Superintendent O'Mara concluded that I was not in compliance. So I think she's capable of determining whether or not she was in compliance.
I object to that characterization of the situation here, but I don't believe that is true. She obviously was operating under the guidance of legal counsel.
So the objection, the original objection, is going to be sustained, and we'll go ahead and ask the next question.
Okay. On November 30th, 2021, was I still employed by the district?
You were you were currently at that time on unpaid leave through the district.
On November 30th, 2021, which duties under the contract between me and the district were being performed?
The district was not providing you with any pay or benefits at that time.
Had the contract been terminated?
The contract was not terminated until April board meeting of 2022.
During November, did you commence a procedure for dismissal pursuant to ORS 342.805 through ORS 342.937?
No.
During November, did I present you with any contract grievances?
No.
On November 30th, 2021, was the district in compliance with OAR 333-019 1033B?
Same objection as the same question. It's already been ruled on.
On December 31st, 2021, which contract duties had the district performed during December?
None.
Had the contract been terminated?
No.
During December, did you begin a procedure for dismissal pursuant to ORS 342.805 through ORS 342.937?
No.
Was I reinstated during December?
No.
During December, did I present you with any contract grievances?
No.
On December 31st, was I still employed by the district?
On unpaid leave, yes.
And I'll skip the compliance question since that was objected to and sustained. 1 second. On January, I just want to clarify real quick. Earlier, you referred to what you not allowing me to work anymore as a suspension, but now you're referring to it as an unpaid leave. Can you explain to me why you've changed the wording from suspension to unpaid leave?
I think they're both the same. But unpaid leave is more it explains more that you were on unpaid leave. Like it wasn't just a suspension, because you can be suspended with pay, you can be suspended without pay. So by saying you were on unpaid leave, it's a little clearer that you were unpaid.
So you said that a suspension can be paid or unpaid. Can you show me where in the statutes that we just were looking at that is a possibility that I could be suspended without pay?
I believe that the witness is testifying here that she was on an unpaid leave status, not an unpaid suspension status.
It seems that she sees that unpaid leave and suspension are the same. And so the suspension, when a suspension occurs under the statute, it is a requirement of the law to pay the teacher during the time of suspension. So I'm wondering how a paid suspension is equivalent to an unpaid leave when
you were never put on paid or unpaid suspension. You were put on unpaid leave per the letter I sent you in October.
Okay.
So if I said suspension and then that confused the issue, I apologize. It was considered an unpaid leave.
Okay. Let's see. Can you hold on 1 second here? So Are you testifying that when you unilaterally prohibited me from continuing my teaching duties, listed my teaching position as being open for hiring, and stopped all of my pay and benefits, that it was not a suspension?
You were put on unpaid leave.
So what is a suspension and how does it differ from what you did?
I would have to ask legal counsel for advice on that. I honestly don't know.
Okay. Did I ever request a leave of absence?
No.
On January 31st, 2022, which contractual duties had the district performed during January?
None.
Had the contract been terminated?
No.
During January, did you commence a procedure for dismissal pursuant to ORS 342.805 through 342.937?
No.
Was I reinstated during January?
No.
Had it been more than 5 days since you unilaterally suspended me, or in your phrase, unpaid, put me on unpaid leave from teaching?
Can you ask that question again? Sorry.
Yeah. So had it been more than 5 days since you put me on what you call an unpaid leave?
Yes.
Did I receive any salary or benefits for January?
No.
During January, did I present you with any contract grievances?
No.
On January 31st, 2022, was I still employed by the district?
You were on unpaid leave. So yes, on unpaid leave.
So yes, I was employed by the district.
On unpaid leave, yes.
On January 31st, can't ask, sorry. I'm skipping the questions that was objected to asking. So I'd like to now ask you about February 28th. During the month of February, which of the district's duties under my contract with the district were being performed during the month of February?
If I may object, the district will stipulate that Ms. Walker was not paid for any or required to perform any duties between the time of October 18th through the date of her dismissal.
Okay.
These questions have been asked month by month, but we will stipulate to the fact that there wasn't any pay during that time period.
Okay. I'm just going to finish up asking about the month of February and then move into the interactions that started with the superintendent in March. So February is the last month, and I'll be on. Go.
Finish your February and then we'll move on.
Okay. During the month of February, which of the district's duties under my contract with the district were being performed?
None.
Had the contract been terminated?
No.
During February, did you begin a procedure for dismissal pursuant to ORS 342.805 through 342.937?
No.
During February, was I reinstated?
No.
During February, did I present you with any contract grievances?
No.
On February 28th, 2022, was I still employed by the district?
Yes, on unpaid leave.
So would you say that I was employed by the district between the dates of October 19th, 2021 and April 20th, 2022?
Yes, on unpaid leave.
Did the district pay any civil penalties pursuant to OAR 333-019-1030, section 11, of $500 for every day that I was employed after October 18th, 2021?
No.
Why did the district not pay these civil penalties? in compliance with this rule?
None were levied.
So, so you're, so do you hold a license issued by the Oregon TSPC?
Yes,
What license do you hold?
I hold both a teaching license and an administrative license.
Okay. I'd like us to now go to Exhibit A25, which is ORS 342.175 grounds for discipline.
Hold on just a minute. A25, correct?
A25, correct. So this Oregon statute states the statutory grounds for discipline of TSPC license holders other than contract teachers. As, my next question pertains to this law. You stated in the 20-day termination notice that by not being in compliance with OAR 333-019-1030, the TSPC could find that I have committed a gross neglect of duty or find that I am grossly unfit to perform my duties as a teacher. Could the TSPC also find that you have committed a gross neglect of duty or are grossly unfit to perform your duties as an administrator for your admitted non-compliance with OAR 333-019-1030?
I don't believe I admitted to that.
Okay. Do you think it is a double standard for you to recommend that I be dismissed for not complying with an administrative rule that if that you yourself were not complying with?
I don't understand the question.
So the rule says that you may not employ, that districts may not employ teachers who are not vaccinated or have accepted a religious or medical exception. And you're saying that I was employed from October 19th through April 20th. So since I was employed by the district, then that would be not complying with that part of the OHA rule.
You were employed, but you were not paid. And so under and this was from legal counsel guidance, it was, we could put you on unpaid leave, and then that met the standard of the vaccine mandate put down from the governor.
Okay. Do you think that termination for noncompliance with OAR 333-019-1030 would be an excessive punishment for an administrator, but not an excessive punishment for a contract teacher?
Object to the irrelevance of what her opinion is on that matter.
And that's going to be sustained.
Okay.
Let's go on to the next question.
All right. I'd like to go on to Exhibit A85. This is the September 13th email titled Unvaccinated Staff Information. Again, this is A85.
Okay.
In your September 13th, 2021 email, you provide me with 4 options. The beginning of option 1 states, request an unpaid leave of absence from October 19th, 2021 until the remainder of the school year. Why did you include the word request in option number 1?
Because you can request an unpaid leave. Any teacher can.
Okay. Are you aware of any law or provision in the collective bargaining agreement or school policy that allows an administrator to place a contract teacher on an unpaid leave of absence without the contract teacher herself requesting an unpaid leave of absence?
Yes, an administrator can place a teacher on unpaid or a staff member on unpaid leave.
And could you cite the authority that you used to place me on unpaid leave?
No, I would have to ask legal counsel again.
Okay, so you can't cite a law or any policy that you made that decision based on?
It was based on legal advice from legal counsel.
Okay. To your knowledge, did I ever request an unpaid leave of absence from the district during the 2021-2022 school year?
No,
To your knowledge, did I ever request a paid leave of absence from the district during the 2021-2022 school year?
no.
I'd now like to go to Exhibit A11, which is the September 21st, 2021 letter that you sent me.
Ms. Walker, what exhibit was that again, please?
I'm sorry, Exhibit A11.
Thank you.
Is Ms. Hungerford ready?
Yes, I am ready. Thank you.
Why did you include in option 3, request a year leave of absence in the September 21st letter?
Well, it's the same option that was provided to you in the email that I sent.
Okay. Why was requesting a year leave of absence given to me as an option if, as you stated in this September 21st letter, you were already planning to place me on paid administrative leave pending dismissal?
If a staff member requests a leave of absence, it's unpaid. So it would have the same effect as being placed on an unpaid leave.
But it said on that letter, though, that it would be a paid administrative leave pending dismissal.
On this first letter?
Yes, the September 1st letter.
Yes. At that time, you were going to be put on paid administrative leave pending immediate dismissal.
But you were still giving me the option to take a year leave of absence without pay.
Yes.
And I would need to request that.
Yes.
Were you hoping that I would request an unpaid leave of absence before you were obligated to put me on what you described as a paid administrative leave pending dismissal?
I don't know what I was hoping for. I was just trying to give you options to make it less stressful.
Can you please cite your authority in placing a contract teacher on paid administrative leave?
The same objection as before, calls for legal conclusion. She's testified she was operating under the advice of legal counsel.
Okay. Why did your wording change from paid administrative leave in your September 21st letter to unpaid administrative leave in your October 18th letter?
The September 21st letter, I had intended to put you on paid administrative leave and move for immediate dismissal following October 18th deadline. Rather than go for immediate dismissal, I was giving grace. I was trying to make sure that this was a decision that maybe, as I have stated before, that maybe the administrative rule would not become permanent for the vaccine mandate. More information would become available. Requirements maybe would be changed for additional safety protocols. For the reasons that you stated you weren't going to be vaccinated or follow the safety protocols or file an exception. My hope was that by putting you on unpaid leave through the remainder of the school year, that additional information would become available, whether it's medical or through ODE and the governor's mandate, and that the vaccine rule would maybe not become permanent. However, it became permanent. And so that's why the verbiage changed from paid administrative leave pending dismissal to unpaid leave through March.
Okay. I'd like us to now go to Exhibit A65.
Okay.
So this is the Mapleton School District Policy 32, policy on leaves and absences. Are you familiar with the Mapleton School District policy regarding leaves of absences?
Yes.
During this last 2021-2022 school year, did I ever request to use any of my accumulated sick leave or request either paid or unpaid leave of absence?
I don't know about sick leave, but you did not request an unpaid leave or paid leave of absence.
The second to last paragraph of this policy states the following: sickness or other unavoidable circumstances which prevent a teacher from teaching 20 school days immediately following the exhaustion of sick leave accumulated under Oregon law will result in the teacher being placed on unpaid leave. During this last school year, prior to October 19th, did I ever give you any indication that I was sick or going to be unable to work because of exhausting all of my sick leave?
No.
If exhausting all of my accumulated sick leave is the condition upon which I can be placed on unpaid leave, why did you place me on unpaid leave without ensuring that I met that condition?
I'm going to object to the question. It assumes a fact, which is not in evidence here. That is that it requires the exhaustion of paid sick leave before any unpaid suspension can be implemented.
Okay, well, I was just reading what the policy said, and that the policy says that sick leave must be exhausted before a person is placed on unpaid leave without that's the condition in order to place an employee on unpaid leave. So I was just referring to the policy.
Again, legal interpretation, that's not the sole condition. That paragraph addresses a situation where a teacher is out on sick leave and then when they exhaust the sick leave, but that's not the condition here.
Sustain it and move on.
Okay. Also in this school policy regarding leaves and absences, it states the following: other paid and unpaid leaves will be determined by the district's negotiated agreements. Where would a contract teacher look to find these negotiated agreements?
That's the collective bargaining agreement.
Okay. So I'd like to go to that question. Did it A67 where it talks about unpaid leave?
I'm going to object to questions that involve the interpretation of a provision of the collective bargaining agreement. I think we've already established that that's not a matter before this panel. This grievant, this ex-teacher, had the opportunity to challenge that through her association. There was no grievance filed, and exhaustion of the provisions under a collective bargaining agreement for any further steps are in the province of the association. So the interpretation of this collective bargaining agreement provision is not before this panel, and so I would object to questions about the meaning of it.
So may I make a response to that? Okay, so I am representing myself. The collective bargaining agreement says I have the right to union representation, but I do not have to have union representation. So since I'm the one who signed the June 15th contract, I'm wanting to represent myself because I'm the one who stated I would be committed to fulfilling my duties. So while it is an option for me to have union representation, it's not a requirement. Also, with regards to the collective bargaining agreement, that is what governs the contract. And I understand that this panel is not required or able even to make a judgment on my grievances, which I did file upon realizing that, well, I should say, I did file grievances, multiple of them actually, once it became apparent to me from my judgment that the district had violated the law and the collective bargaining agreement. So I did actually meet the criteria for making the superintendent aware of my grievances during the time that I became aware of it, which is not until the end of February. So
Okay, so just as a clarification, so if you wanted to take the grievance process, you can do that, and you can represent yourself through that process and the grievance procedure. Option you have is taking it to this panel. And so because we are here and we are this panel, we're going to sustain the objection regarding anything to do with the CBA or interpreting it, because this is not our purview. And so we're going to sustain the objection on questionings on this section of the CBA.
Okay. May I ask a question regarding what you just said?
Yes.
So there are points within my questioning later that address the collective bargaining agreement, but not in terms of asking the panel to make a judgment on my grievances, but rather to show that if the school district is not following the collective bargaining agreement when they say I have been employed, then that could be probative evidence that they were treating me as a non-employee before they terminated me, which then would suggest that that was possibly a fair dismissal, which I do think is under the jurisdiction of the Fair Dismissal Appeals Board.
If I may be heard, it still depends upon a question of interpretation of the collective bargaining agreement, and which this panel is not empowered to do.
And that's correct. So we don't do anything with the CBA. So if there was a violation of the collective bargaining agreement, follows the grievance process that you do through your local association.
Okay, thank you.
Yep.
So to your knowledge, did I ever request that the board grant me an unpaid leave of absence?
No.
If on October, let's see, can an unpaid administrative leave go on indefinitely?
It can, however, that goes against advice of legal counsel.
Could the district have continued my unpaid administrative leave until the end of my contract?
We could have, but that would have gone against advice of legal counsel.
Why was it chosen not to have me stay on unpaid administrative leave till the end of my contract?
Based on advice of legal counsel.
Okay. What rule or guideline or policy governs the maximum length of an unpaid administrative leave?
I don't know.
When you unilaterally put a teacher on an unpaid administrative leave, does the teacher have any recourse to appeal that decision?
It would be through their union representation and through the CBA.
So where is the grievance proceed? So under the collective bargaining agreement. So
Correct.
So these policies from the Mapleton School District and the collective bargaining agreement are for employees, correct?
Correct.
Non-employees So for example, those who have resigned or been dismissed or never worked at the school cannot have employment grievances heard by the district, correct?
Correct.
Under what circumstances can the district decline to hear an employment grievance from an employee?
It has to be filed within the timeline specified in the grievance process in the CBA.
Okay. And if we, in the CBA, there is a discovery time, like once it's discovered that a grievance has happened, then the person has a certain amount of time to make their grievance known to the district, correct?
Correct.
Is it accurate to say that all employees during the course of their employment have access to the grievance procedures and can have their grievances heard by the district?
Yes, as long as the procedures are followed, yes.
If a teacher files a grievance and it is ignored and left unheard by the district, might that teacher assume that she was no longer considered an employee?
I don't know.
Okay, I'd like to go back to Exhibit A11.
Okay.
Okay. In your letter written to me on September 11th, 2021, you state that the district has decided to post your position in order to minimize any disruption to student instruction. Who all in the district made this decision to post my teaching position?
I did.
Do you remember me offering to teach my classes remotely in order to avoid disrupting student learning?
Yes.
Was that option considered by those in the district? Was that option considered by you?
Yes.
Okay. And why did you consider that as an option?
Because you offered that as an option. However, I was unable to allow that to happen based on legal advice from legal counsel.
When did the district post my teaching position?
I don't remember.
Was it in September?
I don't remember.
Was it before October 18th?
I don't remember.
Okay. But you would say though that it was sometime in the, would you say it was sometime in the fall?
I honestly don't remember. I'd have to look it up.
Okay. So since it was, you posted the teaching position, you said in order to not disrupt student learning, would it be safe to say that you were hoping to fill that position before October 19th, when I would no longer be able to teach at the district?
I don't remember when we posted the position or not. When we knew you weren't going to be able to teach on campus and be teaching, we posted a position. I was not hopeful that we would fill it at whenever we posted it. It's hard to find teachers mid-year.
What would the district have done with my teaching contract with the district if that position had been filled between October 19th, 2021 and March 1st, 2022?
Nothing would have changed with your contract and with what we were doing with you.
So you would have hired an additional employee and keep me under contract with the district?
Anytime you post a position after the school year starts, you post it temporary for the remainder of the school year. And then it's determined after the end of the school year if you are going to continue to post that position or fill it with somebody else. So it would have been posted as a temporary position.
So what would the district have done with my teaching contract in that case?
Nothing. It wouldn't have changed. It wouldn't have changed.
Okay, it wouldn't have been terminated.
No.
When did you learn that OAR 333-019-1030 became permanent?
I believe that happened in January or early February.
Why did you not decide to send a statutorily required 20-day termination notice once you learned that OAR 333-019-1030 became permanent?
I guess, again, I was hoping that enough information would come out that maybe things would change and the circumstances would change regarding your employment.
Do you believe it is ethical for a district to require district staff to receive a medical treatment as a condition of employment?
Can you ask that question again?
Yes. Do you believe it is ethical for a district to require district staff to receive a medical treatment as a condition of employment?
I'm going to object to the question. Are we talking about ethical under what set of standards?
So ethical in terms of something being lawful or right. I guess making a decision according to your personal conscience.
Well, I would object to then based upon the fact that all she can testify to would be her personal conscience, or, but I don't believe that that's probative of any issue before this panel.
And I'd like to address that objection. I believe that it is probative in establishing why Superintendent O'Mara's actions towards me over the course of the school year seem very inconsistent, contradictory, and confusing, and therefore unfair to me in trying to represent myself and my rights in my dealings with the district. It is very possible that on the one hand, Superintendent O'Mara was wanting to act in a way that didn't violate her conscience, but on the other hand, she felt pressured to follow legal counsel that violated her conscience.
You know, I think the motivations of the superintendent here have little to do with the legal questions before this panel. The question here is whether the district had the right under the fair dismissal law to dismiss this teacher when they did. So again, object to launching into what may be a whole another area of questioning about people's ethical beliefs.
Okay. So yeah, this is getting into kind of a gray area. Based on the question, though, I think I'm going to overrule and allow Ms. O'Mara to answer that question. But just as a reminder to everybody here, what we're here for is to understand if the district did follow proper procedure through this process. So I'm going to allow the question, but I just want to refocus everybody on what our job is here today. So can you ask the question again so that, because we kind of had a bird walk there.
Yes. Do you believe it is ethical for a district to require district staff to receive a medical treatment as a condition of employment?
Yes.
Do you believe it is ethical to require district staff to submit a statement of religious beliefs as a condition of employment?
Yes.
All right, so I'd like to go on to Exhibit A9. So Exhibit A9 is a letter dated March 1st, 2022, which was hand delivered to you on March 1st, 2022. And then also right behind that is Exhibit 10, which is a letter dated March 7th, 2022, reiterating those grievances. At the time you received these letters, was I employed by the district?
Yes, you're on unpaid leave.
In these letters, I accuse the district of violating the law, specifically ORS 342.875, and of breaching its contract with me by violating the collective bargaining agreement, section 7.3. I also requested reinstatement with back pay pursuant to ORS 342.875. Did you respond to these grievance letters?
I did not respond to the March 1st letter. I did respond to the March 7th letter.
And when did you respond to the March 7th letter?
I would have to look. March 9th. Nope. It would have been. I'm looking.
No problem.
19.
March 10th, I sent you an email that I was in receipt of your letter dated March 7th. It's District Exhibit D16.
Okay, and that is also, I think Mr. Pope mentioned it's also Exhibit A19 in my exhibits as well. Okay, so there's 2 other exhibits. I don't know if you have like some sticky notes to kind of keep things together, but I'd like to introduce also Exhibit A88, which is the pre-termination email that you sent me, and also Exhibit A13, which is the March 4th, 2022 pre-termination notice email that you sent me. So again, that's Exhibit A88 and Exhibit A13.
Are we looking at A19 or not?
I just wanted to make the panel and also the witness aware of kind of where those were, because I will be referring to them in some of my questioning.
Okay.
Okay. Did you email me a pre-termination letter on March 4th, 2022?
Yes, I did.
Did you write this March 4th pre-termination letter yourself?
The email?
The letter attached to the email.
Is that also part of A88?
So the letter itself is A13.
I wrote that letter in consultation with legal counsel.
Why was this letter not sent to me prior to October 19th, 2022, the date I was not allowed by the district to work on campus or receive pay?
Because this notice because you had until March 1st to notify the district if you were going to be compliant with ORS with the vaccine mandate. And so until March 1st, you still had the opportunity to become compliant with that vaccine mandate. And so I didn't want to do pre-termination or termination until after that date.
Why was this March 4th letter left unsigned?
It was because it was sent in an email.
I believe the earlier letters that you sent me, the March 21st, October 18th, were signed. So you had the capability then, but not now. So is that still?
It could have just been an oversight. I didn't even realize it wasn't signed.
Okay. And so again, what prompted you to send the March 4th pre-termination letter?
So the pre-termination letter is not actually required. It's actually an additional notification. Hey, here's the pre-termination letter. Here's what I'm recommending. I'd like to talk to you about it before I make the final decision. Let's meet, let's talk about it and see if there's, if I do have to go ahead with termination or if things have changed.
Okay. In your March 4th, 2022 email and letter, why did you choose not to address the grievances I brought up in my hand-delivered March 1st, 2022 letter?
They had nothing to do with the termination, with the pre-termination notice. They had nothing to do with that.
Were you intending to address my grievances?
You address them to, well, you address them to the school board as well. And so the school board was dealing with the grievances. I also believe based on the CBA, it was outside of the grievance timeline, at least per the union.
So were you making your decision not to address my grievances based on your thinking that I had not met the timeline?
That's correct.
I'd like to now have you turn to Exhibit A19. So this is a letter dated March 10th and signed to you. Did you write this letter?
Yes.
In your March 10th letter, you state the purpose of this communication is to acknowledge receipt of your letter dated March 7th, 2022. Was that the only purpose of this letter?
That's what it states. So yes.
Did you acknowledge receipt of my March 1st letter?
In this letter?
Yes.
No.
Did you ever acknowledge, to your knowledge, my March 1st letter, the grievances of my March 1st letter?
The only acknowledgement would have been when you handed it to me.
Was there any other purpose that this March 10th letter was intended to serve?
No.
Why did you send the March 1st, or I'm sorry, forgive me. Why did you send the March 4th pre-termination letter before sending your March 10th letter addressing the grievances outlined in my March 1st and March 4th and March 7th letters?
The March 4th letter was sent prior to receiving the March 7th letter that you sent to me regarding, and the school board regarding your other grievances.
Okay. So why did you send the March 4th pre-termination letter before sending your March 10th letter addressing the grievances I outlined in my March 1st and March 7th letters?
I had not planned on.
She's already testified to the fact that this March 10th letter did not serve the purpose of being the pre-termination, but simply to give one last chance for there to be a discussion about other options.
So my question, let me see if I can clarify this. So what I'm specifically wanting to know is, why did you send the March 4th pre-termination letter before sending the March 10th letter addressing the grievances outlined in my March 1st letters? I understand that, you got the March 7th letter after March 4th, but I'm wondering why you never addressed my grievances on March 1st, I gave you on March 1st in your March 4th pre-termination letter.
The letter on March.
I'm going to step in here and take care of the objection. And so this has been asked and answered. So we're going to sustain that and move on. Okay.
Okay. I'd like to go to Exhibit A77. This is the 20-day termination notice. So the date of your 20-day termination notice was March 9th, 2022. Was I already terminated by March 9th, 2022?
No,
Why did you write your March 9th 20-day termination notice before addressing the grievances outlined in my March 1st and March 7th letters in your March 10th letter?
Asked and answered.
I actually disagree with that. I was asking specifically related to the March 4th letter in the previous question, and now I'm asking this question related to the March 9th 20-day termination letter.
She's already testified that the grievances were untimely as far as she was concerned. So I don't know that there's any distinction to be made here about multiple requests on the grievances.
I'm going to overrule that and let the witness answer the question.
I'll repeat the question. Why did you write your March 9th 20-day termination notice before addressing the grievances outlined in my March 1st and March 7th letters in your March 10th letter?
the grievances, in my opinion, had nothing to do with the termination. That they weren't timely, they weren't there, they weren't, the grievances were not expressed based on the timeline in the CBA and through the union process put in place. After the March 7th letter, upon advice of legal counsel, I addressed the grievances put forth by you. Whether it was March 9th or March 10th is technically the date on the letter, within a day. So that's why.
Was it your intention for me to have my teaching contract terminated by the school district before I had an opportunity to have my grievances addressed by the school board?
No, it was my thought that the grievances were untimely. They did not follow the grievance timeline, therefore they were not being heard.
I'm just looking through my questions and seeing if there are some that I might be able to skip. So I would like to go back to the exhibit A13, the March 4th pre-termination letter. So again, exhibit A13. So again, I don't know if I've asked you this question related to this particular letter, the pre-termination letter. What was the purpose of that March 4th pre-termination letter?
It was to offer a meeting to discuss before I made my final determination whether I was going to move for termination.
Would it surprise you if I viewed your March 4th pre-termination email and letter as a threat instead of a genuine response to the grievances I made against the district?
I'll object to the question, cause for nothing that has any probative value in this hearing.
That's just,
Okay. If in the March 4th letter, you make no attempt to address my grievances, but rather present a list of alleged charges against me, which also mentioned the threat of TSPC revoking my teaching license. Would it surprise you? I guess it's kind of the same question. It's related to feeling a little bit intimidated by that response to my grievances. I'll go on to the next question.
thank you.
Okay. So before your March 4th pre-termination letter, how many times had you suggested resignation to me as an option?
After October 18th, I don't believe I did.
Okay. Prior to October 18th, did you ever offer resignation to me as an option?
I believe it was in the email I sent and the letters I sent with the options that you had in regards to the vaccine mandate. I believe.
Okay. When you sent this pre-termination letter, did you believe it would put pressure on me to resign?
No.
Excuse me, I'm just looking through my questions here.
I don't suppose there's a way we could take a little break.
Yeah, actually, I would appreciate one myself. So,
Yeah, I was thinking we were getting close. I don't know how many more questions you have. So we will go ahead and take a break. It is 11:45. And so let's take a 15-minute and resume at 12. Ms. Walker, do you happen to, kind of have a timeline on how many more questions you may have? I want to make sure you get all of them in, but also looking at lunch and some of that.
yeah, I still have quite a few more questions to ask. So, I mean, I would say if we want to take a lunch break, if this now is a good time for a lunch break, we can. Or if we want to take a 15-minute break and then do a few more questions, that's fine too. But I do anticipate using a significant amount of the remaining time of the day to ask my questions.
Okay, so I am going to say we are going to break for lunch and let everybody have a chance to do that. So we will pause the record until 12:45 today and have a lunch break. So we'll see everybody back at 12:45.
Okay, thank you.
Thank you.
Please make sure you mute your cameras and stuff, please.
Mr. Pope?
Yes.
Hello. Hi. Did you get my chat message about the cloud?
So this, the host of this will be ODE and Sarah. And so she should be able to have access enough to send that to you. So we'll make sure that you and Sarah connect at the end to make sure you have access to it.
Okay, thank you.
I
All
see
right.
what you're saying, Carolyn. It is Zoom to cloud, but it happens to be my cloud because I'm the host of the meeting.
Right. I just figured that out like an hour ago.
Oh man. Okay. Well, as soon as it downloads, I'll share it with you. I'll forward it to you or something.
Wonderful. And typically I get both the audio and the video.
Yeah, I think it'll be this whole meeting. I think it'll come up like an MP4, so you'll just be able to like watch it like a video.
Wonderful. Thank you. And then we have the YouTube as a backup. So thank you.
Absolutely. Yes.
Awesome. All right. That sounds good. I'm just making sure if Jonathan and Miss Walker and Miss O'Mara are all on.
I'm present. This is John.
Thank you.
I'm present. This is Jody.
Thank you, Jody.
And I'm present as well. This is Julene.
Perfect. All right. With that, perfect. We are back from lunch and we are now on the record again. At this time, Ms. Walker, you are questioning Ms. O'Mara, and it is your time. You're muted.
Sorry. Okay. Now there we go. All right. So I'm gonna have us go back to Exhibit A10. And that is the March 7th letter. In my March 10th letter, do I reiterate my grievances outlined in my March 1st letter, as well as my commitment to upholding my end of my 2-year contract with the district?
Asked, and I believe that the document speaks for itself.
Okay. So you've already mentioned that you wrote this letter. Are you certain that March 10th is the date of this letter?
Which letter are you referring to?
The March 7th letter. Oh, sorry, excuse me. The March 10th letter. That's A19. I'm sorry. You go to A19.
19. Okay.
Yeah. So again, my question is, are you certain that March 10th is the date of this letter?
It's dated March 10th. Yes.
In the first full paragraph, you stated that the district, quote, has acted, the past perfect tense, in accordance with the CBA and the law when making the decision to recommend your employment with the district be terminated. But later in the letter, the paragraph that starts with your March 7th letter, in that paragraph there, it states, quote, I have not yet sent the statutorily required 20-day written notice. Rather, I have provided you with a pre-termination letter indicating that I was considering making this recommendation. So at the beginning of the letter, you wrote that you had already made the decision to recommend my dismissal, but later in the letter, you wrote that you were only considering making such a recommendation. Is that correct?
The decision was at the beginning of the letter, it states that the district has acted in accordance with both the CBA and state law when making the decision to place you on unpaid administrative leave And when making the decision to recommend that your employment with the district be terminated, it doesn't say that we made that decision yet. It says that we are following state law and the CBA when we make those decisions and in making those decisions. So my decision had not been made, but this letter was sent to acknowledge receipt of your March 7th letter of your contract grievances or the grievances that you had with the district. And these were in response to your allegations. And so those were the reasons given for not, I guess that is in response to your allegations.
Okay. And then I'd like us to turn to Exhibit A25. So this is a document that was added to my personnel file on June 1st. It's titled Documents for Termination of Julian M. Walker.
Did you say A25?
Yes. Oh, sorry, 125. Sorry, 125.
I'm sorry,
Apologize for that.
a little time to get there.
Yes.
Okay.
Okay. So this is a list of documents, and one of which you informed me were being placed in my personnel file on June 1st, nearly 1.5 months after I was dismissed. My question is, who compiled these documents and provided this 2-page list of documents?
I did.
On page 2 of this document list is a document with the date of 3/9/2022. That is titled 20-day termination letter sent certified return receipt request to Julene and FDAB. Is that accurate?
Yes.
You're referring, excuse me, to page 2, some line on page 2 of 125.
Yeah. So on Exhibit A25, page 2, and Superintendent O'Mara listed the dates of the documents and what events pertain to those documents. So I'm mentioning the one on 3/9/2022, which would have been March 9th, 2022. Okay, so it states there 20-day termination letter sent certified return receipt request, return receipt to Julene and FDAB.
Correct.
So your statement of sending this letter on March 9th, 2022 is in contradiction with your letter to me dated March 10th, in which you stated that you were considering making a recommendation to the district board that I be dismissed. If you had already made the recommendation on March 9th, why did you tell me otherwise on March 10th?
Miss O'Mara, did you hear that question?
I did. I'm looking at the documents. I guess I guess I don't understand the question. It's whether it was sent on the 9th or the 10th, or the letter was written on the 9th and mailed on the 10th.
Okay.
When I send a 20-day termination letter, that is notification to you that I am moving for termination. And so if the letter dated 3/10 was sent on 3/10 or 3/9, it was in response to your March 7th letter. And as of March 7th, no, I had not decided whether we had not determined what we were doing as a district with legal counsel. So whether the date is the 9th or the 10th, the letter stands, and I stand behind the letter I wrote.
Okay. Other than your March 10th letter, did you address the grievances outlined in my March 1st and March 7th letters in any way?
No.
Are you aware that after I received your letter of March 10th, in which you stated that my allegations against you and the district were, quote, not true, I addressed my grievance to the district board?
Yes.
Do you think that you were making it clear to me what was going on with my employment after leaving me in complete limbo about my employment from October 19th until March 10th?
I'm going to object. I don't think that the question about speculating what was understood by this questioner is really something that this witness can answer.
You have a response, Ms. Walker?
I'll allow you to make that decision.
Okay, and then I'm going to sustain that, and we'll move on.
Okay. In your March 10th response to my accusation of your violations of Oregon law and the collective bargaining agreement, you state the following. However, quote, however, this is not true. Contrary to your allegations, the district has acted in accordance with both the CBA and state law. Do you still stand by that statement?
Yes.
In this letter written as a response to my grievance, did you cite any authority for placing me on unpaid administrative leave?
I'd have to look at the letter again. Which exhibit was it?
Let me pull that up for you. March.
Again, best evidence rule here. If she's asking what's in a letter, she can simply give us the exhibit number of the letter and the panel can review that letter.
Okay. Let me.
Is this the March 10th letter?
Yes, the March 10th letter.
Okay.
I was just going to try to find the exhibit number. Can you try to find that for me? I think it's. One moment, please. Yes, it's exhibit A19. So the March 10th letter is exhibit A19. Thanks for trying. Okay. So in this letter, written as a response to my grievance, did you inform me that you believed I did not meet the timeline outlined in the collective bargaining agreement in filing my grievance?
Again, the letter speaks for itself, asking this witness to refer to the letter, read the letter, introduce it as an exhibit. It's already in as an exhibit.
I do think that this particular question needs to be asked because it was brought up in this testimony of the superintendent that the reason she did not address my grievances was because I did not meet the timeline. And I would like her to state to me whether or not she informed me of that in this March 10th letter to address my grievances.
I believe I have a continuing objection to any questions as to whether or not the district met the requirements of the collective bargaining agreement or any provision of that collective bargaining agreement. That's a matter that is outside of the purview of this panel.
So that objection has been sustained. Just as a reminder, any time you use the term grievance, that implies the CBA. And so that we're diving down that road again. So the using the CBA or the term grievance is following the grievance procedure in the CBA. And again, that's not part of our scope. So just for the record on that. So the original question was in regards to something in this letter.
Mm-hmm.
Do you have a question that is not something that we can read in that letter?
Yes. So may I address the panel chair?
Yes.
Yeah. So I just so it was brought up in this testimony that the reason my grievances were not addressed was because I didn't meet the timeline, but I did not become aware of that until the district's attorney informed me of that this summer. So my question is, I think it's important for the panel to know if there was any time while I was employed that the superintendent did or did not address my grievances. So may I ask the question, while I was employed by the district, did the superintendent ever inform me that I did not meet the timeline for filing for a grievance?
And that's not a part of our scope. So our scope is nothing to do with the timelines that are set out in the CBA. When you choose to come to the FDAB panel, you essentially waive your rights for a grievance procedure, including any timelines that have or have not been met. So that's just a part of how this works. You kind of have two options: the grievance procedure or the FDAB panel. And because we're in the FDAB panel, we do not entertain anything to do with the CBA or grievances.
Okay, I would just like to put it on the record that the fact that the school district was not treating me as an employee by following the collective bargaining agreement is evidence that I was not employed during the time that Superintendent O'Mara is alleging that I was employed. And then
I'll object to that interpretation, because I believe that what's been testified to here is that their timelines were not met. And for that reason, the district did not proceed with any processing under the CBA. And I think that's really as far as we need to get into this topic of the CBA.
Yeah, we're not going to go down the road of the CBA at all.
Can I address something that is actually not a fact that the district's attorney just said? She said that I did not meet the deadline for the grievance timeline, and I actually did. And that obviously can't be a stipulated fact, but I would argue, as I did in my opening statement, that I did.
We would challenge that, but I think it's a waste of time here to challenge that. Whether or not she met the timelines is a part of compliance with the CBA, and it is not for this panel to determine.
Okay, so at this point, let's just go ahead and continue with questions for Ms. O'Mara moving forward. And just a reminder, we are not going to be doing anything with the CBA. And that way everybody's clear on that.
Okay.
Thank you.
Mm-hmm. On that date, March 10th, 2022, the district made a decision to recommend that my employment with the district be terminated.
Yes.
Pursuant to ORS 342.805 through 342.937, only a superintendent may make a recommendation to the district that the employment of a contract teacher be terminated. Were you calling yourself the district in this sentence?
Which letter are you referring to?
The March 10th letter, which is Exhibit A19.
Just a minute. Which section in the letter?
It is the last sentence in the first paragraph where it says the district has acted in accordance with both the CBA and state law when making the decision to place you on unpaid administrative leave, and so on?
So you're asking if that's me, if I'm the district?
Yes.
Yes, I am the district representative.
Okay, so you're calling yourself the district in that sentence.
Well, it's the Mapleton School District. So yes, we as a district acted. Yes.
Okay. So if you are the district and you are making recommendation to the district that my employment should be terminated, what role did the district school board play in my termination?
I recommend termination to the school board. They conduct a hearing and then they either accept my recommendation for termination or they deny it.
Was the termination process complete already on March 10th?
No.
From October 19th, 2021 until March 4th, 2022, my employment status was static. As you testified earlier, nothing changed in the month of November, nothing changed in the month of December, nothing changed in the month of January, other than the item that you testified to before the board that the OHA had made OAR 333-019-1030 permanent. Nothing changed in the month of February. Month after month, you had not reinstated me and you had withheld my pay and allowances. Is that accurate?
Yes.
But something did change on March 1st. On March 1st, I made a grievance against you in the school district for violating the law and the collective bargaining agreement. And on March 4th, after you had received my grievance, but before you had responded to it, you sent me a so-called pre-termination notice. Is that an accurate timeline?
Yes.
A pre-termination is not required by law, nor does it have any legal significance. Is that correct?
I'm going
Correct.
to object to questions about the law. That's for the panel to decide. And I don't believe that asking this witness or making assertions about the law furthers the inquiry here at all.
Okay. The so-called pre-termination notice would not have commenced a procedure for the dismissal of a contract teacher pursuant to ORS 342.805 through 342.937, as that would have required you to send a 20-day notice. Was your March 4th, 2022 pre-termination notice sent as a retaliatory action because I had accused you of being in violation of the law and had demanded back pay and reinstatement pursuant to the law?
Absolutely not.
As you have established with your testimony, nothing had changed at all in my status for months, but suddenly when I tried to assert my rights, you threatened to dismiss me. Can you explain the timing of your March 4th letter threatening to recommend my dismissal?
The witness has already answered the question, and continuing to harangue the witness about the answer doesn't further the inquiry of the board here.
Did you play any part in determining the format or time restrictions for the hearing that took place during the executive session of the school board meeting on April 20th, 2022?
That was all done with legal counsel.
Were you a part of that decision with the board, with legal counsel?
That was a board decision regarding whether the format for the appeal board for the format for the appeal hearing for your termination is set. That doesn't usually change, and the board chair and legal counsel are the ones that determine time frame.
Did you recommend or agree with the restriction that there be no witness testimony during the April 20th hearing and executive session?
Yes.
Did you recommend or agree with the restriction that I be permitted only 15 minutes to make my defense against the 5 grounds for dismissal that you had made against me, plus make my grievances against the district for violation of the law, breach of contract, and violations of the legal process required to terminating a contract teacher?
I agreed with, did not recommend, but I agreed with it.
Had you and the board already jointly decided that I would be terminated prior to my hearing in executive session on April 20th?
Absolutely not.
If the board had not already decided to terminate me prior to my hearing, why was I only allowed 15 minutes to address my grievances with the district and defend myself against the 5 charges you listed in your 20-day termination notice?
Again, I'm going to object. These are legal questions. She's already testified that the legal authority that the district was consulting with recommended and put this procedure into place. There is, in fact, no requirement of any specific length of hearing. And because of the fact that there is an appeal available through fair dismissal, that has been determined to meet those requirements for due process. So again, we're asking this witness to speculate about or to respond to questions about the law. I think those would be appropriate if the spokesperson here, if Ms. Walker wants to raise those in a brief and cite authority to that effect, but we are wasting our time here haranguing this witness about those questions.
Yep, and she answered that question. So we're gonna sustain the objection by the district and move on.
Okay. Did you testify at the hearing during the executive session of the April 20th Mapleton School Board meeting?
Yes.
Did you present any facts during the hearing in support of the charges you alleged against me in your 20-day notice?
Yes.
And what facts did you present?
They are listed in Exhibit D22 for the district.
And could you explain to me how what you have here in your statement are facts that support the 5 charges in your 20-day termination notice?
I guess, again, the letter speaks for itself.
Yeah, we can read the letter. So that's going to sustain that.
Let's see here. Okay, since you already have the district statement as Exhibit D22, the corresponding exhibit that I have is A51. I'm going to be asking some questions related to that exhibit. So either A51, my exhibit binder, or D22, the district's exhibit binder. Could you please tell me who wrote this statement?
I did.
Are you referring to yourself as the district?
As the superintendent, yes, I am the district.
What was the purpose of this document?
It was the statement to the board as to why I was recommending termination of your teaching employment.
Did you read this statement before or after the school board voted to terminate my contract?
Before.
Why did you entitle this district statement on termination if I had not yet been terminated?
Because that is my statement on why I was moving for termination of your employment.
In the final paragraph on page 2, up at the top, it states the following: based on the information presented and written documents I have provided to the board, I am recommending the Mapleton School Board approve the termination of Julene Walker effective immediately. Why did you recommend that the Mapleton School Board approve my termination if I had not already been terminated prior to your reading of the statement?
You were not terminated prior to the reading of this statement. I was recommending that they approve the termination.
Okay, it just, the wording says that approve my termination. So I was just, it doesn't say my recommendation for termination. So I was just trying to get some clarification on that wording. So did you mean to say in that document, approve my recommendation for termination?
No, I meant to say that I recommend the Mapleton School Board approve the termination of Julian Walker effective immediately.
Okay. I'd like us to turn to Exhibit A80. You can put it in there. Are you ready?
Yes.
Yes.
Okay. So on June 1st, nearly a month and a half after I was dismissed, I received this notification by email that the documents included as 2 attachments to this email were being added to my personnel file. If you
I'm going to object to questions on this line, it has to do with the contract provision 7.8 personnel files. And again, I think that's outside of the scope of this hearing.
this particular question isn't related to the personnel files.
So we're looking at Exhibit A80, is that correct?
Yes, but just as a reference of more of like the date of when I received this and to help know kind of when I refer to the next document, I just want to let the panel know that it was one of the documents that was attached to this particular email. The document that I will be focusing on is Exhibit A78. So we can just move right there. So this was among those attachments that you sent to me on June 1st. Did you give this document that title?
The executive session appeal hearing?
Yes.
Yes, I labeled it.
Why did you call the April 20th hearing that took place in executive session before the school board an appeal hearing?
I guess I believe that's what it's called. Maybe I titled it wrong. I don't know.
Okay. In your mind, had I already been terminated prior to April 20th?
No.
Then why did you refer to the hearing as an appeal hearing if I had not already been dismissed?
So the process is I recommend termination to the school board. I send a 20-day termination letter to both you and the FDAB panel. Once I send the 20-day letter, that's putting you on notice that you will be terminated 20 days. I'm going to recommend termination at the next board meeting. That was happening at the April 20th board meeting. If you wanted to appeal that recommendation, then you are allowed to have an appeal hearing to appeal the recommendation for the termination of your employment. So that would be why it would be determined or called an appeal hearing for my recommending your termination.
In my 28-page document submitted to the board, I title my document as a defense against the recommendation for termination because I didn't feel yet I was hoping, I should say, that I wouldn't have already been terminated. So I was defending that recommendation. But by using the word appeal, it seems as though I had already been terminated even before the April 20th hearing. But we'll move on to the next questions.
Thank you.
Let's see. So the next two exhibits that I'm going to be referring to, if you want to maybe make, put some stickies there. So exhibit A32 and exhibit A1.
Okay.
Okay, so these are my email and letter of March 15th, 2022, sent to the school board and copied to you and Jaren Ricks. In my email with this attached letter, I requested that my grievances be added to the agenda for the next school board meeting. I did that pursuant to Article 3 of the collective bargaining agreement. Did you receive this email?
Again, I'm going to object to questions about this. It involves a grievance procedure. We've already gone over this ground that the determination was that the grievance was untimely, but regardless, it doesn't matter because that is a question that could have been presented to the grievance procedure through the grievance procedure. The association did not carry that forward. And again, we're just repeating argument that's been made already, which is that there were violations of the grievance procedure.
I would just like to say that I was actually representing myself. I chose not to have the union represent me. I wanted to represent myself. And I was actually trying to set up a time with the district to have my grievances heard, and I was not.
And that's fine. You don't have to necessarily have an association member with you to go through the grievance process. But we are not, again, where our view is not the grievance procedure, the timeliness of grievance procedure, or any of that. We are strictly FDAB, which is the appeal to the process. So we're going to sustain the objection that this is regarding the CBA and a grievance procedure with that.
I'm going to need to look through my questions real quick and see where to go next.
Okay.
Yeah. Let's see. Was I an employee of the district on March 15th?
Yes.
Can someone who is not an employee of the district file a grievance against the school district?
Again, I'll object to the questions having to do with the grievance procedure.
Yep. The term grievance, Ms. Walker, has to deal with the CBA, and that's again, we're not in our scope. So maybe if you need something different, we choose different words, but the term grievance is a grievance procedure, and that is outlined in CBAs.
So you testified that you presented during the April 20th hearing. Approximately how long was your testimony?
I read the statement that is Exhibit D22 that's what I read for the in the hearing.
did your testimony, so that statement there on D22 and D22 was the entirety of your defense of my allegations that you had violated ORS 342.875?
No, this is my district statement on termination as to why you were being recommended for termination. I also provided the board members with additional documentation prior to the board meeting.
Let's see here. In the 20-day termination notice or in your testimony before the board, did you cite any authority for what you did or explain why you believed you were not in breach of contract or in violation of ORS 342.875?
The witness has already indicated that she read this statement to the board and that was the extent of her presentation before the board. Best evidence rule, we have exhibit 22, D22 in the record.
Okay. So I'd like us to go to A124. Okay. So these are the performance evaluations from my personnel file that you sent to the TSPC John LaFollette on May 13th, 2022. Once you located my performance evaluations from the 2017, 2018, and the 2018 and 2019 school years, did you take time to review them?
You mean, did I look over them?
Yes.
No.
Do you trust the judgment of my direct supervisor, high school principal Brenda Moyer?
Yes, absolutely.
Do you believe she evaluated me fairly and truthfully in these performance evaluations?
Yes.
Have you ever read these performance evaluations of mine?
No.
Did you find anything in my personnel file that would have provided evidence to substantiate any of the allegations you made against me in your 20-day termination notice?
No.
Okay, so I'm going to go to now exhibit A43.
Excuse me, what number again?
I'm sorry, A43.
A43, thank you.
You're welcome. All right, are you ready?
Mm-hmm.
So have you read this 28-page defense against termination recommendation with the accompanying 31 exhibits that I submitted to the school board 8 days before the April 20th hearing?
No.
Will you please turn to page 20 in my defense against termination recommendation? Based on the average score that I received for all of the 6 domains and my 2 student learning goals for the 2017-2018 school year, how would you rate my overall teaching performance for that year from the following options? Does not meet standard.
I'm going to object to questions about her performance on these standards and on this material in her file. This was not a dismissal that was related in any way to inadequate performance. These were not considerations that are mentioned in the letter. This is simply additional information that has no relevance to the decision that the board made.
I will skip down to my next questions then.
Okay, thank you.
Mhm. During the COVID-19 pandemic, when the Mapleton School District was doing comprehensive distance learning, did you have any concerns or receive any complaints about my individual performance teaching my courses remotely?
No.
During the 2020 and 2021 school year, when we moved to limited in-person instruction, and I volunteered to be one of the teachers who provided in-person support to students while we were still unable to provide in-person instruction for the entire school day, did you have any concerns or receive any complaints that I was not following the safety protocols for limited in-person instruction?
No.
When the entire district moved to in-person instruction for the spring semester in 2021, did you ever have any complaints that I was refusing to wear a mask?
No.
Did you ever have any complaints that I was refusing to fill out and complete the daily contact tracing logs?
No.
Did you ever have any complaints that I was refusing to follow any of the other safety protocols?
No.
In your opinion, did you find that during the COVID-19 pandemic, I was cooperative in adhering to the safety protocols as they changed over time for our district?
Yes.
Prior to August 30th, 2021, did you ever feel that there was a need for me to sign a contract to ensure that I would follow all safety protocols related to COVID-19?
No.
Why did that become a new need for me to sign a contract to ensure that I would follow all the safety protocols?
For staff members who chose to get a religious or medical exception rather than receive the vaccine, they were required to follow additional safety protocols. In order to ensure that they understood and knew what all of those additional safety protocols were, they did sign an agreement that they agreed to follow those safety protocols. And that was through legal counsel and PACE insurance process.
Okay. Prior to August 30th, 2021, did you ever feel that there was a need for me to sign a contract to ensure that I would fulfill all my teaching duties?
You did that when you signed the contract in July or in June of each year.
To your knowledge, did I ever not do something that I signed that I would do in my role as a contract teacher?
Not to my knowledge.
Is the OHA the authority over me as a contract teacher?
The district is the authority over you as a contract teacher.
How do you define insubordination?
Not following the expectations of a teacher or a staff member set forth by the district.
Can you cite any law, provision in the US or Oregon constitutions or term of my contract with the district that would obligate me to follow OAR 333-019-1030.
I'm going to object. Question of legal determination here. I think that this can be argued if Ms. Walker wants to, can be argued in the brief. But there's no reason. The superintendent has already explained the rationale for making the recommendation.
May I address that, panel chair? So in response to that objection, I would just like to say that Superintendent O'Mara has alleged multiple times that I have violated the law in her 20-day termination notice. If she is able to accuse me of violating the law, I feel like she should be able to support that accusation by citing the law upon which the OHA's rule is standing.
Again, she consulted with legal counsel for her to be able to trace the OHA. She said that the OHA rules are the reason why your non-compliance with those was considered insubordination and therefore grounds for termination. So in terms of any arguments you want to make that OHA regulations don't reflect constitutional law or violation of constitutional law or whatever, you're free to make that, but it's not probative here for this witness.
So I'm going to overrule the objection and let Ms. O'Mara state whether or not she knew the law or not. And that was the question.
So I will go ahead and repeat the question. Can you cite any law, provision in the US or Oregon constitutions or term of my June 15th teaching contract with the district that would obligate me to follow OAR 333-019-1030?
So based on the information that I have, it would be your inability and refusal to follow Permanent Administrative Order 333-019-1030. That's why you were terminated.
So does that flow from a law to your knowledge?
Whether it's a law or a rule or a mandate, it's something that the district has to follow in order to be able to maintain not just PACE coverage, but as well as not get fined and as well as to keep all of our students and staff safe. That was the mandate and the basis for the mandate that the governor had. So whether it's a rule, an OAR, an ORS, a TSPC expectation, a standard, it's something that the district was required to follow. So that is why I followed that rule, that mandate regarding the vaccine, and that is why you were terminated.
To your knowledge, does this regulation directly violate other statutes where the legislature expressly states its intention concerning medical care, employment in general, and the employment of teachers specifically?
Not to my knowledge, but I'm not a lawyer.
To your knowledge, do these, okay. So to your knowledge, do any of the, so as its statutory authority, the Oregon Health Authority cites ORS 413.042, ORS 431A.010, ORS 431.110, and ORS 433.004. To your knowledge, do these laws express vaccination as a condition of employment?
I don't know what those are.
Okay. Has the legislature designated any of its rulemaking authority for the employment of contract teachers to the OHA?
I don't know.
Moving back to the 20-day termination notice, Exhibit A77. When you wrote, actually, I don't know, you might need a little time to get there. So it's Exhibit A77. Are you ready?
Yeah.
Okay. When you wrote the 20-day termination notice, did you know the definition of insubordination?
Yes.
Did you look at the definition of insubordination used by the FDAB?
Not specifically, no.
We heard testimony from one of the board members where she stated, quote, "I don't care about the language" when it came to the charges that you alleged against me in your 20-day notice. Do you agree that the language of the charges alleged against me in your 20-day notice, including insubordination, doesn't matter?
No, I think it absolutely matters.
So in the 20-day notice, at the first grounds for dismissal alleged against me, the grounds are insubordination. In this document, did you provide facts as to the different elements of insubordination?
Yes.
Does this document state those things?
Yes.
Does this document establish to whom I was insubordinate?
I'm looking.
Okay.
It says on the second page, an Oregon state law requires teachers to, so you would be insubordinate to either the state of Oregon and or the district because you were directed to get vaccinated. That's also on page 1.
So you're saying that I was insubordinate to Oregon state law?
I'm saying that's the reason. On page 1 under ORS 342-8651, it says you have been directed to get vaccinated or request an exception and you've refused to do so. Your failure to follow this workplace directive, so the workplace would be the district where you work, insubordination and grounds for termination, it constituted insubordination and grounds for termination.
So who in the district gave me this workplace directive?
I did.
Did you state that in this 20-day notice?
Again, the document speaks for itself. There are other documents in the files that have to deal with this question. And so a rhetorical question about whether it was stated or stated clearly or whatever, this is not the best evidence. The best evidence is for the panel to look at the letter and to look at the previous directive.
So my response to that would be that she is telling me that the district gave me this directive, and I'm wanting to have her clarify whether she means that she was the district. And if she was, then I'm asking her to show me in the document that she was the one specifically requesting me to do or telling me to do that.
So I'm going to sustain the objection. It is in here in our books where those are. So let's go on to the next question, let's go on to the next question.
Okay, so to the board chair, or I have a panel chair, I'd just like to say that part of establishing whether someone is insubordinate or not is to establish the different elements that make up insubordination. And so I'm asking questions specific to this letter to bring forth whether or not this letter, this 20-day notice, has all of those elements that is required to charge someone with insubordination.
Correct. And that's also under our view. Our view is to make sure that the legal piece was followed. And so we're going to continue to hear that evidence. So maybe rephrasing the question to make it so that it's getting at what you want without contradicting the document or having us read the document or having Ms. O'Mara read the document we can do that as we make a determination.
Okay. Does this document establish that the directive given to me by someone in authority over me was lawful for that authority?
Was that a question for me?
No, I'm sorry. That was for Superintendent O'Mara.
Okay, can you repeat that question again then?
Yes. Does this document establish that the directive given to me by someone in authority over me was lawful for that authority?
I believe it does, yes.
Does this document establish that I was defiant in my disobedience to lawful authority?
Yes, I believe it does.
Based on the 20-day notice, if the district board had found that the conduct you, based on the 20-day notice, if the district board had found that the conduct you alleged was true, how would the board have established whether the alleged conduct substantiated the charge of insubordination based upon the facts you presented in your 20-day notice?
The board received additional information other than the 20-day letter and my statement that supported the recommendation for termination.
If the district board found that I was directed to be vaccinated or to request an exception, but did not, but they also found that I was directed to do so by a bus driver, would that be insubordinate?
I'm object to a theoretical question of this sort, which is not probative again of the issue before the panel.
Okay. Would you agree that the fact of the identity of the alleged authority is important to establish insubordination?
Yes.
So to the panel, I would like to introduce a new exhibit that I have discovered based upon the school district's attorney's opening statement, which comes from the FDAB's own website under Fair Dismissal Appeals Board grounds for dismissal under Educator's Resource. On this web page is a section entitled Review of the Enumerated Statutory Grounds as Interpreted in FDAB Cases, which has a subsection called Insubordination. Since the district's attorney used this information in her opening statement, she should already know about it. Therefore, I contend that I too should be allowed to use it.
I have no problem with you using it in terms of your written statement at the end of this, but to introduce it for this witness at this time, I believe is inappropriate.
Do you have like copies of this also? Like that's another question I have. Like, can we make sure everybody has it in front of them? Like, I'm more curious about that also.
Yeah, so I have it saved as a PDF that I could email to everyone and our like group email thread. So I have it saved as a PDF. If we took a break, I could email that to everybody.
Okay.
Object because this is exactly what happens in post-termination argument, arguing from case precedent that this particular situation does not meet some standard that has been set by prior decisions. It's not necessary that that be part of the cross-examination of any or direct examination of any witness. She's free to bring up those case decisions and attach them for the panel and to argue that conditions set out in prior determinations are not met here. But for there to be testimony about it, this witness has no knowledge of those prior decisions or hearings. So there's really nothing that can be gained by bringing it up here with this witness.
May I respond to that?
Yes.
So I'm not asking the superintendent to know or be familiar at all with the cases. I just want to use the FDAB's definition of what insubordinate is and ask the superintendent questions related to whether or not the way she used insubordinate and provided or did not provide facts meet those different elements of the FDAB definition of insubordination.
And I would argue that there are probably 50 decisions by the Fair Dismissal Appeals Board since its inception that deal with the statutory criteria of insubordination. So for her to use one decision, ask this witness whether she agrees or not, I think is a complete waste of time here for the panel.
Okay, so on the objection, I'm going to sustain the objection. Legal definitions will be beyond this witness's scope and knowledge. And so we're going to sustain the objection on this, because this is not something that Ms. O'Mara is in her knowledge. So it's been an hour since our last break. Do we need to take a quick break to kind of have a moment, and then we can reconvene? So we're going to go ahead and just probably 6 minutes. So at 1:55, we will pause the record until 1:55.
Thank you.
Thank
Yeah.
you.
Thank you.
before we go back on, I just want to make sure that John Hartsock is here and Ms. Walker. There's John.
I'm present.
Thank you. All right, so we will now go back on record as it is 1:55.
Okay,
All right, Ms. Walker, thank you.
yes. So I do have a question to the panel chair. So in talking about the 20-day notice, I'm trying to have Superintendent O'Mara authenticate the 20-day notice. In other words, I'm trying to establish that the 20-day notice meets the statutory requirements of ORS 342.895-3A. If there is some other way besides looking at the 20-day termination notice to do that, I would like to know how to do that so I know how to go about establishing whether this particular 20-day notice meets the requirements for the ORS.
If it helps, I could try to weigh in to kind of provide a little feedback as opposed to advice, right?
Okay.
You definitely don't want to ask her about legal conclusions. You can ask her about facts and dates that she knows about. And if that helps at all, in terms of that's what she could talk about, what she knows. But asking about legal conclusions or whether it complies with the statute is kind of out of bounds because that's not a decision for her. Asking questions that may have been part of the conversation she had with her counsel or the counsel for the district is kind of out of bounds because basically privileged. So those are kind of the parameters to operate within, facts that she directly knows. And if she doesn't know, then I wouldn't pursue a line of questioning. That would be my feedback. I don't know if that helps, but.
May I ask a question about what you said?
Yes.
So, is the panel going to, since I'm not able to question the superintendent about whether this 20-day notice establishes or has the necessary elements required by the statute, is the panel themselves going to know to look at the 20-day notice and make sure those elements are there that are required by the statute?
You can ask her about the letter in the panel. That letter is in evidence, so the panel will definitely review that evidence, and you can definitely ask facts around that letter. I just was watching through time a line of questioning, and I was hoping to not, my goal is to try to clarify with it. So a line of questioning can be pursued. It can't be pursued along the lines of did it comply with the law or not. It's just the facts that she is aware of in terms of composing the letter. And the panel is going to review all evidence in the record. And this is already in the record.
If I may ask a question and follow up, it's always been my understanding that the purpose of the written closing brief is to direct the panel to look at this particular case law or the statute and to make those arguments there, as opposed to asking a non-lawyer witness about whether this complies with the law or something.
So yeah, and this may help actually. The legal argument, the parties are going to have an opportunity, if they should so choose, to write a legal brief after this hearing where they put together all this and say, hey, look at all this evidence that's in front of you, look at the testimony, or consider the testimony you just heard from these witnesses. This is how it ties together. Asking questions of witnesses regarding their legal conclusions would not be proper because it's something that's outside of their expertise and their understanding. And it's frankly hard to have statutes and rules memorized, especially if you're not an attorney. But I think that's pretty much how this panel in these cases have been heard through time, is that the parties close, they submit a brief later on tying together the arguments that they have come across, as opposed to trying to bring arguments or legal positions through witnesses. So I don't know if that helps.
Okay, so I am still able to ask questions about the 20-day notice as long as they're not questions related to the legality of of the rules.
Asking for her legal conclusion about a document would not be a proper question. Asking for her factual understanding around the document. And I know that might be a blurry boundary between fact and law because the law speaks to facts. So I understand there's a degree in which there's a gray area for sure. But I mean, obviously, if you pursue a line of questioning, there's an objection, it will be considered. I'm trying to help refine it so that there's focus and maybe an understanding of why there might be certain objections that are being raised, being sustained, and then there's still a path to navigate where you can ask a line of questioning that is okay here. And it's just basically within her knowledge, within the realm of her experience, what she has perceived, that she's aware of. And if she says she doesn't know, she doesn't know, and you have to kind of move on from that because she can't testify to what she doesn't know about.
Mhm. Okay, so I will do my best to, not have her ask or answer questions regarding about the legality of rules. However, I would like to, if it's okay with the panel, if I have their permission, to continue to my line of questioning related to the 20-day notice.
Well, I will raise objections whenever I believe that we're going beyond questions about facts that this witness would have knowledge of. And when we get into questions of interpretation, I will continue to raise objections.
Okay.
To answer the question, yes, we can still ask questions around the 20-day letter. And but now I think we're a little more focused on where we're going. Is that good? Are we okay with that?
Yes, I'll just keep plugging along.
I appreciate that.
All right. The one issue that I do have is that this particular document, the 20-day notice, contains multiple legal conclusions made by Jody. And so it seems a little bit unfair for her to be able to make a legal conclusion that she doesn't now have to defend for making during this hearing.
Well,
That might be an example. That might be an example of legal argument, or asking a question along the lines of, "Do you know?" And if she says, "I don't know," later on that could be raised as an argument by you. So I have to, again, this is where I need to make sure I'm not giving advice. So everything you just articulated is a legal argument. If that makes sense.
Okay. So I guess I'll just keep moving through the questions, and if there's objections, then if I can address them, I will. If not, we'll just keep moving along. So thank you everyone for your patience. All right. In the 20-day notice and stating that the statutory grounds for dismissal, which you cite as ORS 342.865 section 1C, which is from exhibit A3 for reference. You have printed in boldface type insubordination for failing to follow a workplace directive, but this is not an accurate quotation of the statutory grounds listed in ORS 342.8651C. And the other grounds that you set out, you quoted the statutory grounds exactly, but here you added, quote, for failing to follow a workplace directive. The actual text of the law simply says insubordination. Why did you add this additional wording in your 20-day notice?
This letter was written in consultation with district counsel, legal counsel. And so they provided me the verbiage to use for grounds of termination.
Were you attempting to substitute your own definition of insubordination?
No.
Do you think that what you did there might have the potential to have misled the district board members in their attempts to determine whether the alleged conduct constituted insubordination?
Cause for speculation.
ORS 342.895.3 requires your 20-day notice to set forth the statutory grounds upon which the superintendent believes such a dismissal is justified and have a plain and concise statement of the facts. Do you believe you met that standard by not clearly delineating what you were setting forth in the statutory grounds and when you were making statements and allegations?
I believe I made it very clear.
If you believe that failing to follow a workplace directive constitutes insubordination, wasn't it your job to present evidence of that belief rather than presenting failing to follow a workplace directive as if that was the standard of insubordination set out in the statute and is further defined and interpreted by the FDAB in prior cases?
This is argumentative. It's not a question for this witness. It calls for a legal conclusion.
Okay. What statements contained in my personnel file on March 9th, 2022, did you present as evidence in the 20-day notice that I failed to follow a workplace directive?
None.
What evidence other than your conclusory statement, which was this is quote, your failure to follow this workplace directive constitutes insubordination. So what evidence other than your conclusory statement under the insubordination charge did you present in the 20-day notice that failure to follow workplace directive is insubordination?
In the letter, it states, the second page, the Oregon state law that requires teachers to get vaccinated, and about your refusal and what that constitutes, gross unfitness as well as insubordination.
Okay. Looking again at the the FDAB interpretation of insubordination requires a defiant intention on the part of the teacher. It then goes.
That's only one of the possible definitions in the Oregon statute and case law. It is not a requirement in all cases. So you're asserting an interpretation of the law that is not correct.
So I'm not saying that's the complete definition. I'm just saying that's one of the elements that the FDAB has for the definition of insubordination.
And you are implying that's a necessary element. It is not a necessary element. Not according to the case law for best prior cases.
Did you allege in the 20-day termination notice or establish with facts that I was defiant?
I would say yes, based on your refusal to comply with the mandate.
And so now we're going to go to Exhibit A83. Okay, so this is a September 3rd, 2021 email from you to me entitled Vaccine Information.
Excuse me, is this A3? Because I'm seeing a copy of the statute.
Oh, sorry, it's A83. I apologize.
Sorry.
So again, Exhibit A83. And again, this is a September 3rd, 2021 email from Superintendent O'Mara to me entitled Vaccine Information, but it more accurately provides communication regarding the testing requirement. In your September 3rd, 2021 email, you state the following. I also attached the information/process for the weekly testing program that all unvaccinated staff, regardless of which exception they choose, will be required to participate in, and a staff screening fact sheet that ODE has as well. Let's plan to meet next week to discuss your decision and see if you have any additional questions. based on your September 3rd email response, would it be safe to say that as of September 3rd, 2021, I was still exploring my options regarding seeking an exception?
Yes.
Would it also be safe to say that I wanted more information about the additional requirements that would go along with seeking an exception?
Yes.
In any of our interactions revolving around the district's enforcement of OAR 333-019-1030, did you ever find me to be disrespectful?
No.
Do you remember meeting with me on September 29th, 2022 to inform the staff that as of October 18th, 2021, I would no longer be teaching at Mapleton?
Can't remember the exact date, so give me 1 second.
Yeah.
I remember meeting with you to tell students and staff. Yes, let's see.
Yeah, I believe we met with staff on the Wednesday, and then the students on the Thursday, the 30th. So do you remember meeting with the students and staff?
Yes, yes, I do.
Okay. Together with me, correct?
Yes, yes.
How would you describe my level of cooperation with you during these meetings with students and staff?
I guess I don't understand the question. I mean, we were collegial.
Yeah.
There was no animosity.
Mm-hmm. Okay. On September 30th, 2021, you and I spoke to each of my classes. Do you remember what you said to me in the district office while I was making copies in the district office?
No.
Do you remember saying something along the lines of, Julian, there is no one else I would rather have gone through this with than you?
I don't remember saying that, but it sounds like something I would probably say.
Would you have said something like this to me if you felt that I was being defiant or insubordinate to you during our interactions this fall?
No.
Do you remember asking me to organize the high school supply closet on Monday, October 18th, 2021, the last day I was allowed to teach?
I actually don't remember that. I know that I had a conversation with the high school principal about it, but I don't remember if I asked or if she asked. I don't remember.
Okay. And did you look at the photos for A105 when Brenda was looking at them earlier?
Yes.
Based on these 4 photos that I took after organizing the high school supply closet, do you believe I successfully followed your workplace directive to organize the high school supply closet on October 18th, 2021?
Yes.
So now I'd like us to turn to Exhibit A82, which is the vaccination update dash August 30th, 2021 PowerPoint, that section of it. So this Exhibit A82 has 5 different attachments to it. So it's an email with 5 attachments. And the section that I want to direct us to is the PowerPoint from the first day of in-service, which is the last attachment. And you can see that the PowerPoint is kind of sideways if you're looking for a visual to know where it starts. It says a vaccination update there. Okay, so at the end of that, which is also the end of the exhibit, completely, there's a final PowerPoint slide that I would like to ask you some questions about. So, so this is from the first day of in-service. On the last page of this PowerPoint entitled Declaring Vaccination Status and Proof, it states, each of you must declare in person to Jody by the end of day Tuesday, August 31st, 2021, your vaccination status or plan. Why was it necessary for staff members to declare their vaccination status or plan to you in person?
My goal was to have an individual meeting with each person, just to talk about what the expectations were and answer any questions that they had.
Did I follow your workplace directive to meet with you in person the morning of Tuesday, August 31st, 2021?
We met, you and I met, I believe we met before the staff meeting. We had a meeting on the 31st. We had one on the 23rd and then one again on the 31st.
Yeah, I actually don't remember the one on the 23rd. So, I personally don't remember that, but I do remember we had in-service, shared the PowerPoint presentation with us, told the staff about the requirements. And then afterwards, I wasn't ready to talk about it, but then I did schedule a meeting with you on Tuesday, the following day, about what you wanted to be speaking of. So does that sound accurate to you?
Yeah, it does.
So on that day, Tuesday, August 31st, before knowing my rights guaranteed to me by the state and federal constitutions, as well as the state and federal laws, did I declare to you my vaccination status and ask you several questions regarding the requirements of the vaccine mandate?
Yes.
So still in that same exhibit, but towards the beginning, at the very beginning, there's the email. So I'd like us to go of that same exhibit, A82. In your August 31st, 2021 email sent out to staff, you sent out a reminder to staff which stated, please remember by the end of day today, Tuesday, you were to have declared one of the following. 1, you are fully vaccinated and will show proof of vaccination. 2, you plan to be fully vaccinated as defined in the vaccine status packet by October 18th, 2021. 3, you plan to file a medical exception. 4, you plan to file a religious exception. 5, you do not plan to get vaccinated or file an exception. What would have happened to a staff person who did not make a declaration of any of those 5 things?
At that point in time, nothing until October 18th, when they either had to have an exception filed or the vaccine be fully vaccinated.
Okay. Would it have been considered insubordinate for a staff person to choose not to declare their vaccination status?
At that time, no, but after October 18th, yes.
Would it have been considered insubordinate for a staff person to choose to declare their vaccination status?
Say that again?
So would it have been considered insubordinate for a staff person to choose to declare their vaccination status?
No.
Which in your mind would be considered more insubordinate if a staff person was unvaccinated? 1, to declare their unvaccinated status, or 2, to declare their or 2, to not declare their unvaccinated status?
Can you say that again?
Yes, I apologize. I mutilated the reading of it, so that's my bad. So which in your mind would be considered more insubordinate if a staff person was unvaccinated? So 1, declare their unvaccinated status, or not to declare their unvaccinated status?
After or before October 18th?
Before October 18th.
It wouldn't matter before October 18th.
Would it matter after October 18th?
Yes.
So it would be, in your mind, it would be considered not insubordinate before October 18th, but then insubordinate after October 18th.
To not declare whether they're vaccinated or not. Yes.
Okay. So now I'd like to go to Exhibit A21. So, so this is the Americans with Disabilities Act, and there's also A20 right before that, which is the ORS 659A.136, along with some other Oregon statutes. And so these two exhibits speak to the rights of people, of employees, to keep medical information private. So what disciplinary action would you have taken toward a district staff person who exercised her right to medical privacy provided by the Americans with Disabilities Act 42 of the United States Code 126, as well as the corresponding Oregon law, ORS 659A.136, and chose not to declare their unvaccinated or vaccinated status to you?
That calls for a legal conclusion as to whether or not there are opportunities under the governor's directive and the OHA, which there are, if a medical exemption is called for. But in this case, this teacher did not ask for a medical exemption. So this is really an irrelevant question at this point.
I'll move on to the next question. For insubordination, who was directing me to get vaccinated or request an exception?
I was.
Would it be, let's see. During your time as superintendent for the Mapleton School District, did it become an expectation that all contract teachers would follow every rule promulgated by every administrative agency in the state of Oregon?
Ask the question again, please.
Yes. During your time as superintendent for the Mapleton School District, did it become an expectation that all contract teachers would follow every rule promulgated by every administrative agency in the state of Oregon?
You'd have to define administrative agency in the state of Oregon. Define them.
So, so basically, there are a bunch of administrative agencies that are authority by Oregon statutes to make rules. So we have like the Oregon Department of Transportation, the Oregon Department of Fish and Wildlife. We have the Oregon Health Authority. We have a number of different agencies. So my question is, during your time as superintendent for the Mapleton School District, did it become an expectation that all contract teachers would follow every rule promulgated by every administrative agency in the state of Oregon?
I don't know the answer to that question.
Okay. If the Oregon Department of Fish and Wildlife created a rule that all K-12 staff had to purchase a fishing license every school year, would the Mapleton School District require all K-12 staff to do so?
I think this witness has already testified that she can't answer a number of these questions because they call for a legal conclusion.
Okay, we'll move on to the next one. Exhibit A84 will be our next exhibit.
What number was that again?
I'm sorry, exhibit A84.
Thank you.
This is a September 6th, 2021 email from Superintendent O'Mara to district staff entitled Unvaccinated Staff. On September 6th, 2021, you sent out an email entitled Unvaccinated Staff, where you list additional expectations for unvaccinated staff. In this email, you state the following: these expectations are meant to help keep you, staff, and students safe. There are additional safety protocols that will be expected. These will be discussed at the individual meetings scheduled for next week. Do you stand by your statement that these additional expectations for unvaccinated staff were meant to keep unvaccinated staff, all staff, and students safe?
Yes.
Do you have any evidence to show that I refuse to follow any of the additional expectations outlined as numbers 1 through 4 in this email?
No.
Going to the next exhibit over, Exhibit A85, the September 13th, 2021 email. Attached to this email are the extra safety protocols. And those are titled, if you turn to the 3rd page of Exhibit A85, the top of it says Mapleton School District 32 Unvaccinated Staff Safety Protocols. Are these the additional safety protocols all unvaccinated staff would have been required to follow?
Yes.
Would people with medical and religious exceptions be required to follow these safety protocols?
Yes.
What would have happened if a person with a religious or medical exception would have chosen not to follow all these safety protocols?
It would have resulted in disciplinary action, up to and including dismissal.
Why was the signature required of staff to follow these additional safety protocols?
To ensure that they understood and agreed to follow them.
You stated in your earlier testimony that you developed these safety protocols, correct?
In collaboration with legal counsel and PACE, our insurance provider.
Who directed you to make these safety protocols a condition of employment for unvaccinated staff?
That was part of the vaccine mandate and ODE's expectation. If unvaccinated staff filed a medical or religious exception, we had to put in place additional safety protocols to ensure that students and staff remained safe.
Okay. And when did they direct you to make these safety protocols a condition of employment for unvaccinated staff?
I believe it was part of, let me look real quick. I think it's in Exhibit D2 for the district, where it states, what about, let me look. On the 2nd page of District Exhibit D2, where it states the first paragraph, schools and school-based programs that grant an exception to the vaccination requirement under this rule must take reasonable steps to ensure that unvaccinated teachers, staff, and volunteers are protected from contracting and spreading COVID-19. Reasonable steps could include, but are not limited to, weekly testing, a fitted N95 mask, additional physical distancing, and/or an isolated work site.
Okay, so this document was dated August 26th. So is that when you were directed to make these safety protocols a condition of employment for unvaccinated staff?
Effective October 18th, yes. And I believe I actually did it sooner than that. Believe we put them in place in September.
Okay. So in Exhibit 80 or A85 still, if we were to turn to the front of that or the first page of that exhibit, that's your September 13th, 2021 email.
Mm-hmm.
in that you gave the following option: agree to follow all safety protocols in place for unvaccinated staff in the Mapleton School District. What was your reasoning for providing me this as an option?
Well, that was one of the expectations.
Okay.
Everybody had the option.
What was that? I'm sorry, you cut out.
All unvaccinated staff, that was one of the things they had to do, was agree to follow the protocols in place for unvaccinated staff.
Would it be possible for an unvaccinated person to have chosen option 3 without filing for a medical or religious exception?
No.
In your opinion, would an unvaccinated person choosing to follow the additional protocols referenced in option 3 be considered a safer staff person than a vaccinated person who did not follow these additional protocols?
Ask the question again, please.
Yeah. So in your opinion, would an unvaccinated person choosing to follow the additional protocols refer or reference in option 3 be considered a safer staff person than a vaccinated person who did not follow these additional protocols?
Not necessarily.
What makes, so what in your mind would make an unvaccinated person safer? Is it because of the staff person's status of being unvaccinated, or because of the additional safety protocols that the unvaccinated staff person was being required to follow?
The purpose of the additional safety protocols for unvaccinated staff was to help to reduce the spread of COVID-19 at that time with the information that ODE and OHA had. And so it wasn't a matter of who was safer, vaccinated or unvaccinated. It was, okay, let's take these two. And if you're unvaccinated, then let's put these safety protocols in place to prevent you from spreading COVID. Let's put these in place for vaccinated staff to prevent the spread of COVID.
So were there also additional vaccination or additional safety protocols that people who were vaccinated had to follow as well?
They still, I mean, they weren't just free to do whatever they wanted. They still had to wear masks and keep it and eating. There were specific rules around eating and protocols for safety that the district put in place for whether you were vaccinated or unvaccinated. You still had to wear masks and physical distancing and washing your hands and hand sanitizers and contact tracing, things like that.
So would the vaccinated staff not be required to follow the additional safety protocols that the unvaccinated staff had to follow?
Correct.
Why weren't all district staff members required to follow these additional safety protocols regardless of their vaccination status?
It wasn't required through PACE.
So still in this exhibit A82, you provided these 5 attachments. Are these attachments that you provided among the documents that PACE would have expected you to use in developing the district safety protocols?
Yes. This actually, you're on 82?
Yes. Uh-huh.
So the PowerPoint was actually provided from Oregon Department of Education.
Okay.
To help explain to staff members and board and community members the requirements for the vaccine, for mask requirements, safety protocols, and things like that.
Okay. What was your intention in sending out these 5 attachments to district staff?
I went over the attachments in the district-wide staff meeting that week. And so I told staff as a follow-up, it was a lot of information for me to give to them. So I told them I would follow up in an email and send them the attachments so they could look through it. And if they had any questions, they could come and ask me any questions they had about it.
Okay. Did you want staff to use this information as an aid for making their decision about whether to become fully vaccinated or ask for a medical or religious exception?
This was one of the tools that was provided. It had questions regarding FAQs. It had the vaccine. It had the actual exception forms in it as well. So this was a part of the toolkit that was provided to staff to help make that. I don't know if it would help them make that determination or not, but I wanted them to have all the information about what was required and what that meant for them being employed at the school district.
Okay, thank you. So the first attachment there is entitled 333-019-1030. Was this one of the 5 documents you sent out to the district staff to educate? Yeah, so we got that. So in OAR 333-019-1030, section 1, which is that first big paragraph there, you can find the following statement. The Delta variant is approximately 2 to 3 times more infectious than early wild type COVID-19 variants. There is emerging evidence that people infected with the Delta variant have similar viral loads regardless of vaccination status, suggesting that even vaccine breakthrough cases may transmit this variant effectively. Being vaccinated is therefore critical to prevent the spread of Delta. Do you find the statements in this OAR contradictory?
At the time, no.
Do you now?
Not necessarily.
Can you explain to me why, even when the OHA admits that people infected with the Delta variant have similar viral loads, regardless of vaccination status, and that even vaccine breakthrough cases may transmit this variant effectively, that the district still made it a requirement for people to show proof of being fully vaccinated against COVID-19?
I was required to do so by the governor's mandate and ODE. So the district had to require.
We can move forward to Exhibit A85. We're going to return back to the Mapleton School District 32 unvaccinated staff safety protocols that was attached to the September 13th email. Are you there now?
Yes.
Okay. Why did you not include this document outlining the additional safety protocols that will be expected as part of your September 6th, 2021 email sent out to all unvaccinated staff?
Including in the what email?
The September 6th email that was sent out to all unvaccinated staff.
The unvaccinated staff safety protocols, I was still developing the expectations in conjunction with PACE and legal counsel to ensure that we had met all of the different expectations for unvaccinated staff safety protocols. So it was still being developed and added to.
Okay. So who from the Mapleton School District besides you approved these safety protocols as the additional safety protocols that unvaccinated staff from the Mapleton School District would be required to follow?
I worked with the Brandon Moyer high school principal, Jaron Ricks, our HR and business manager. I also spoke with Randy Duvall regarding some of the additional protocols for our bus drivers and custodial staff. And then I made sure that the board was aware of the additional safety protocols being put in place.
Thank you. In your testimony on July 13th, when the district's attorney, your district's attorney asked whether the district's insurance carrier PACE would cover you if there were students or staff who could trace a COVID infection to exposure at school? You responded no. Is that correct?
I believe the question was I think it was a more detailed question than that.
Okay. So did PACE say that they would cover you if there were students or staff who could trace a COVID infection to exposure at school?
Only if you enforced the vaccine mandate and or had additional safety protocols in place for unvaccinated staff.
During your time as superintendent, were there ever any cases of COVID-19 that were able to be traced back to exposure at school when district staff was required to fill out contact tracing logs?
No.
Were there ever any cases of COVID-19 that were able to be traced back to exposure at school when the district staff was not required to fill out contract tracing logs during the 2021-2022 school year?
No.
Even after October 18th, when I was no longer allowed to teach for the district, were there any cases that could be traced back to the school?
Not that I'm aware of, no.
Was the district ever threatened or challenged with a lawsuit because of a student's or staff member's exposure to COVID-19 at school?
No.
What is the likelihood that I would have exposed students and staff to COVID-19 if you had allowed me to teach my classes remotely from home as I requested last fall?
You wouldn't have exposed kids, but you wouldn't have been allowed to teach from home.
Okay. In addition to testifying that PACE would not cover the district if there were students or staff who could trace a COVID-19 infection to exposure at school, you state the following: we were told that if districts did not follow the vaccine mandate and or safety protocols expected through ODE and the Ready Schools Safe Learners, that we would lose PACE coverage. Is that correct?
That's correct. And that was based on advice from legal case.
Okay. I'd like to go back to Exhibit A82. And I would specifically like to go to the section that says school and school-based programs, vaccine rules, FAQs, updated 8/26/2021. It's after the religious and medical exception forms.
Okay.
And it starts where it says page 1 of 8 in the bottom right-hand corner. From where did you get this document entitled Schools and School-Based Programs, Vaccine Rule FAQs?
It was provided to us from ODE through Oregon Health Authority. The superintendent group had a Zoom meeting, and all of these documents were provided as a toolkit for us to provide supports to staff.
Was this also a document you provided to the Mapleton School District staff so they could educate themselves about their options regarding the COVID-19 vaccine mandate and medical and religious exceptions?
Yes.
Was this one of the documents you used in developing the safety protocols for unvaccinated staff for the Mapleton School District?
No.
Was this document used or referenced in any of your superintendent meetings facilitated by the Oregon Department of Education?
Yes.
If the ODE representatives reference this document in the meetings that you attended, do you think ODE would have approved of your use of this document in developing safety protocols and educating district staff regarding the COVID-19 vaccine and safety protocols?
Are you asking if ODE approved using this document with staff?
Yeah, did they approve of you using it with staff? Yeah.
Yeah, they gave it to us to use with staff.
Okay. Did PACE approve of you using this document to develop the safety protocols for the district?
I didn't use this document to develop safety protocols with the district.
Okay.
This was simply provided as an FAQ.
So in that particular document, the school and school-based programs, vaccine rule, FAQs, if you go to the page 4, on the bottom, page 4, there's a question and answer. The OHA question states, will there be weekly testing for employees that don't want to be vaccinated? The OHA answer states the following. No, employees need to be fully vaccinated to mitigate the spread of COVID-19 or submit forms to complete a medical or religious exception. Schools that grant medical or religious exceptions must take reasonable steps to ensure that unvaccinated teachers, school staff, and volunteers are protected from contracting the spreading COVID-19. Reasonable steps may include weekly testing, a fitted N95 mask, additional distancing, a face mask with a face shield, a remote workplace, or other step. This document is, and when it was doing this, when it was making, there's a citation, part of that, what I just read was a citation, and it's citing section 9 of OAR 333-019-1030. Do you believe that the safety protocols that you developed were, quote, reasonable steps for the district to ensure that unvaccinated teachers, school staff, and volunteers are protected from contracting and spreading COVID-19?
Yes.
In your testimony on July 13th, you stated that weekly testing was a non-negotiable that had to, and that had to happen, and that was through PACE, end quote. Did you ever ask the PACE attorney why they were making weekly testing a protocol that is non-negotiable when the OHA and ODE is not making it non-negotiable?
No.
Did the PACE attorney say that the weekly testing would make students more safe?
I didn't ask.
If PACE had not been involved in your development of these protocols, do you think you would have been able to develop a different set of reasonable steps to ensure staff and student safety than those outlined in the Mapleton School District number 32 unvaccinated staff safety protocols?
No, I think safety protocols were reasonable, and I think they allowed students and staff to stay safe. So I would not have changed them if PACE changed their mind.
Okay. As stated in the OHA FAQ sheet, could the Mapleton School District have offered staff a remote workplace?
No.
I'm sorry, I didn't hear your response.
I was turning a page. No.
Oh, okay. And why not?
Mapleton School District was returning to in-person learning. We were not going to be offering remote learning to students and staff, and that was not an option for us to do.
Do you remember me asking you if in order to not disrupt student learning, I could teach all of my classes remotely through a video platform?
Are you talking about the beginning of 21-22 school year?
Yes.
Yes, I remember that.
So why did you not allow me to have a remote workplace like the OHA FAQ sheet provided as an option?
Give me 1 second. I believe it's in the district exhibits under D2, where it states, I'm trying to find the verbiage.
Mhm.
Try someplace else. Hold on.
Okay.
I just don't want to misspeak. So
Yeah, that's fine. Sometimes it takes me a little while to find things too. So
it says, so it's quoting OAR 33301911030. Basically what it says is teachers, school staff, and volunteers not teach, work, learn, study, assist, observe, or volunteer at a school unless they are vaccinated or have provided documentation of a medical or religious exception. Under B, it says a school may not employ, contract with, or accept the volunteer services of teachers, school staff, or volunteers who are teaching, working, learning, studying, assisting, observing, or volunteering at a school unless the teachers or school staff are fully vaccinated against COVID-19 or have a documented medical or religious exception. So basically what that means is even if you were teaching remotely, you would still not be able to be employed or teach with the Mapleton School District.
even though I could perform my teaching duties remotely by not be at school.
Correct. You still would have to file a medical or religious exception.
Did you allow a different teacher the option to have a remote workplace during the 2020-2021 school year?
You mean prior to the vaccination mandate?
Yes.
Yes. We were complete remote at that time.
So why did you allow her to have that option and not me when I requested it the following school year?
I couldn't allow you to do that under the O.
Okay. Why was it necessary in your mind for these additional safety protocols that you provided to be discussed at the individual meetings?
Out of respect for each person, I wanted to meet with them individually and talk to them about the safety protocols. It was a two-way meeting. So we met and discussed the safety protocols, making sure they understood them. In some instances, the staff member made some suggestions that might be a better way for them to be able to do their job and still meet the safety protocols. So there were times when safety protocols might have been changed while still following the intent of the safety protocol, but to better enable the staff member to do their job.
Would you now describe at least some of the additional safety protocols outlined on the protocol document that unvaccinated staff were required to sign as punitive?
No.
Did you describe them as punitive to me when we met individually on September 10th, 2021?
I don't believe so. No.
As a superintendent for the district, were you confident enough in the district's enforcement of the OHA rule to take on all of the risk of liability if one of the district staff members had an adverse reaction to the COVID-19 vaccine that the district required them to get?
Can you ask that question again, please?
As the superintendent for the district, were you confident enough in the district's enforcement of the OHA rule to take on all of the risk of liability if one of the district staff members had an adverse reaction to the COVID-19 vaccine that the district required them to get?
I don't. I was confident in our expectations in keeping kids safe and in the safety protocols and keeping kids and students safe. Guess I don't know how to answer that question because I don't know that I would be liable for that, considering it was a state mandate.
Do you know who would be liable for that?
No.
So if a person didn't feel that they qualified for a medical or religious exception, And do you feel that they were still required, they should still be required to get the vaccination?
They either had to get a vaccination or file a medical or religious exception.
When unvaccinated staff are following additional protocols, would having an accepted exception make students and staff safer than an unvaccinated staff member who did not request an exception?
That question has been asked and answered already.
I don't believe it has, actually.
You did ask that one today. That's sustained. That's asked and answered.
Okay, I don't believe I did, but I will move on. So let's see here. When were your letters dated September 21st and October 18th added to my personnel file?
All documents related to your termination were added on June 1st or right about there.
Are you familiar with 7.8.4 of the collective bargaining agreement, which states, quote, teachers shall receive copies of any and all materials placed in their personnel file at the time of original placement?
Again, I'm objecting to any testimony questioning about requirements of the collective bargaining agreement.
Okay.
That's sustained, just for the record.
Okay. Okay. So I'd like to go to Exhibit A3.
A3.
A3. And again, this is the accountability for schools for the 21st century law. If I'm going to be referencing page 4 and 5. Are you familiar with ORS 342.850 that outlines the expectations of the district regarding the maintenance of teacher personnel files?
Yes.
One moment, please. So there's a section on the maintenance of personnel files, and specifically sections 4 through 8. Could you take a moment to read through those, or would you prefer that I read them out loud?
I can read them.
Okay.
Okay.
So are you familiar with these laws governing the maintenance of the personnel files of contract teachers?
Yes.
And if you move ahead to ORS 342.895, section 3A, which is on page 7, it states the following: at least 20 days before recommending to a board the dismissal of the contract teacher, the district superintendent shall give written notice to the contract teacher by certified mail or delivered in person of the intention to make a recommendation to dismiss the teacher. The notice shall set forth the statutory grounds upon which the superintendent believes such dismissal is justified and shall contain a plain and concise statement of the facts relied on to support the statutory grounds for dismissal. If the statutory grounds specified are those in ORS 342.8651 A, C, D, G, or H, then evidence shall be limited to those allegations supported by statements in the personnel file of the teacher on the date of the notice to recommend dismissal, maintained as required in ORS 342.850. Do you believe your 20-day termination notice directed to me met all of those requirements?
I'm going to object. That calls for a legal conclusion. There has been fair dismissal case law that relates to that very issue. And this witness is not an attorney who would be able to interpret that.
Are you aware that pursuant to ORS 342.895 section 3A, the allegation of insubordination is limited to evidence supported by statements in the personnel file of the teacher on the date of the notice to recommend dismissal?
Again, I'm going to object to that because the interpretation of that statute has been the province of the Fair Dismissal Board and Court of Appeals in terms of what exactly is required. And this witness does not have the legal knowledge or background to interpret it.
May I address that?
Yes.
So the superintendent is, from my understanding, is required to follow these statutes in her treatment of me as a contract teacher. So it would seem that part of the role of the superintendent is to have some familiarity with the laws that govern how she treats a contract teacher. So I think these questions related to these particular statutes that apply to her are relevant for her to ask.
She's already testified that she was under the counsel of legal counsel throughout this process. And so asking her to define what these particular statutory requirements is not productive in this hearing.
I'll wait
So
decide on that.
what was that again?
I said I'll wait for you to make your decision on that.
Okay, so yeah, that can go into your brief. So we're going to sustain the objection. If you have questions about facts that you want to ask Ms. O'Mara, then now's your time to do that.
Okay. So on the 20-day termination notice, which is Exhibit A77, can you look at that notice and show me what evidence supported by statements from my personnel file as of March 9th, 2022, you used to substantiate your charges or your charge of insubordination?
There were none from your personnel file listed on there.
At the Mapleton School District, who is in charge of maintaining the personnel files of district employees?
It would be the HR director as well as both building level principals.
Is it a requirement to obtain a subpoena in order for a contract teacher to view her teacher evaluations in her personnel file?
No.
Did you know that my performance evaluations were not in my personnel file when I came in to view and obtain copies of the documents in my personnel file on March 1st, 2022?
No.
So I'd like to go to Exhibit A17. And then, so this A17 is my email correspondence with Jaren Ricks, reading my personnel file after we met. And then I'd like to go to the next exhibit, which is A18. And this is a signed affidavit that recounts not only my interactions with him, but also when you and I met in the presence of Jaron Ricks and also Kathy Dean, who was with me. Do you remember being present with the HR business manager, Jaron Ricks, when I asked to view my personnel file on March 1st, 2022?
Yes.
In Exhibit A3, which we were just at, ORS 342.850, Section 4 through Section 8, among the things that it says in there in Section 4, it says, the evaluation reports shall be maintained in the personnel files of the district. Why were my teacher evaluations not stored in my personnel file?
Typically in school districts, in a building level, you have working files. Every principal has a working file that contains prior year evaluations as well as current ongoing evaluations. And then sometimes at the end of the school year, those evaluations are put in the teacher's permanent file. Sometimes it's when they're no longer with the district or they resign, then they move from their working file into the permanent file, which is held into the district office. So that would be my guess as to why they weren't in your official personnel file with Mr. Ricks in the HR department, is that they were in the working file with Mrs. Moyer.
Okay, I'd like to go to Exhibit A121.
Okay.
So this is the subpoena for records, specifically my records. And it's an email between TSPC and you. In your email response to the TSPC subpoena, you asked John LaFollette if he wanted my performance evaluation sent with all documentation.
Mm-hmm.
Why did you wait until?
Yeah, I need the exhibit number. I misheard it. I thought you said 21.
Oh, I'm sorry. Exhibit A121.
121, sorry. Okay, thank you.
Mm-hmm.
Okay, thank you.
You're welcome. In your email response to the TSPC subpoena, you asked John LaFollette if he wanted my performance evaluation sent with all documentation. Why did you wait until after you were subpoenaed by John LaFollette from TSPC on May 11th, 2022 to ensure that my teacher evaluations were in my personnel file?
I didn't. Once you notified us that your personnel evaluations were not in your file and you asked for copies of them, they were put in your personnel file.
Do you remember the date that I received them by email?
No.
It was June 30th after the pre-hearing conference for this hearing.
I thought you inquired well before then for your performance evaluations.
And I did ask Jaron Ricks. I also called, I emailed Brenda and Jamie for them, the high school secretary. And then Jamie talked with Jaron and talked to you and said that that you had mentioned to her that there wouldn't be any evaluations for the last 2 years. It was as I was preparing for my defense, I was trying to locate my personnel file or my performance evaluations to see if there was anything on there that could be used to substantiate the charges that were being brought against me. So it wasn't until, let me check. I need to verify the date. 1 second. Okay, it should be Exhibit A28. So
on April 4th. That was when you asked and inquired about your evaluations.
yes, so I had tried to locate them initially on March 1st, and they were not in my personnel file. And then I received your pre-termination notice on March 4th, and then your termination notice on the 20th. So then I needed to prepare to make a defense for myself against your recommendation dismissal, against all of the charges that you listed in your 20-day notice. And so in my preparations for that, I was trying to locate my performance evaluations, because that would be a really good source of evidence to determine whether or not those charges are substantiated with facts.
Actually, you're making an assertion there in forming this question, but there was never any basis for dismissal that was indicated that was based upon inadequate performance. So existence of evaluations, or where they might be included, is not an issue here. These are not evaluation-based or performance-based charges. They are listed under other grounds for dismissal.
So two of the charges, the charge of insubordination and the charge of neglect of duty, require there to be evidence from my personnel file. And in the criteria that's used to evaluate teachers are things like professionalism and other like interactions with community and staff. So there could be evidence in a performance evaluation that I was insubordinate or that I might have neglected my duties. Therefore, I feel like it's very relevant to the charges that are being alleged against me.
However, there were no charges about any matters prior to the fall of 2021 regarding insubordination or neglect of duty. So it was well established already that there were no evaluations completed for the prior 2 years. So there really is no basis for believing that there would be information in your evaluations that would have to do with the charges that were being brought.
But I would like to address that in saying that if someone receives a 20-day termination notice with insubordination, neglect of duty, any cause which constitutes ground for the revocation of one's contract teacher license, gross neglect of duty, and gross unfitness, and you don't recall ever having done any of those things, it might make a contract teacher want to make sure that nothing has been added to her personnel files that she should address in her defense before the board.
But in this case, the grounds for insubordination and neglect of duty were clearly spelled out as being your refusal to get vaccinated or to have an exception. There were no other grounds listed. So anything that might have been in prior evaluations was not material, could not be used by the district.
And then I'll rely on the panel chair to determine.
So, yeah, so this is a legal argument, and I'm still trying to find out what the question you're asking Ms. O'Mara is. So in regards to the personnel file, Ms. Hungerford is right that in your 20-day letter, it does not reference performance issues. And so going 2 years back on performance issues is not in front of the panel at this time. If you feel as though there is something that you need to put in your legal brief at the end, we encourage you to do that in regards to what was or was not in your personnel file.
Okay, so I'll go to my next question then.
Excellent, thank you.
Did you know that because of your filing of the misconduct report form, I was under investigation by TSPC?
Yes.
And you knew I was under investigation by TSPC. Why did you question whether John La Follette would want my performance evaluations?
Let me go back to the subpoena.
Yeah, it's Exhibit A 121.
Thank you. The subpoena specifically asks for documents regarding the above named educator, including working files. Let's see, let me go right to it. It says, all complaints, investigations, investigative notes, reports, and related documents or recordings in any personnel or working files in your possession, custody, or control regarding the above license for blah, you.
Mhm.
It says basic personnel documents like payroll contracts and other non-investigation related materials are not requested at this time. Since none of your performance evaluations were used in this dismissal, I specifically wanted to clarify if those were ones he needed because they were not used in the termination, and they were not part of the investigation.
Were you concerned at all that these performance evaluations might refute the charges you outlined in your March 9th 20-day termination notice and the misconduct report form that you completed on April 27th?
No.
So where did you find my performance evaluations?
At that time, they were in your personnel file on April 4th, per the email you sent to Jamie at the high school office. You asked her to scan those performance evaluations. And so she scanned them. And at the same time, we put them in your personnel file where they needed to be. And so I was able to access them from your personnel file.
And per the Oregon statute that governs the maintenance of personnel files, why was I not then informed that those evaluations were added to my personnel file at that time?
When you meet with your administrative evaluator at the end of the year, we always say, I do it too, that, this will be put in your personnel file. That's common knowledge. You are also given a copy of them. Anything that is put in your personnel file, you are, you receive a copy of. You'd already received copies of them when they were completed and signed. And so there was no reason to give you an additional copy of them.
Okay. I'd like to go to Exhibit A80. So in this email, on June 1st, you state the following. Per the collective bargaining agreement 7.8.4, I am attaching all files being placed in your personnel file at the district office regarding your termination. This includes your entire defense against termination recommendation document. So my question is, why were the documents that you added on June 1st, 2022, not present in my personnel file on March 1st when I asked to view them and make copies of the documents in my personnel file?
On advice.
These are not issues that are before the panel because these are provisions that are established by a collective bargaining agreement. Whether or not the district has met the collective bargaining agreement requirements here is not before the panel.
Per the Oregon statute, though, it is a requirement to notify the teacher when documents are being added to the personnel file. So they were not there when I checked on March 1st, but Superintendent O'Mara just testified that then they were then added once I made the request for them. And then, but I did not receive notification that I was receiving them until June 1st.
So the objection is about using this document because it is CBA. And so that has to be sustained because it is the CBA requirements.
Okay. So I'd like to now go to Exhibit A 132. So Exhibit A 132 is a June 30th, 2022 email with attached documents that were requested by me at the June 21st, 2022 pre-hearing conference. Attached to this June 30th, 2022 email you sent me, you can see that my evaluations from those 2 years were included as the last two attachments, and they were entitled as evaluation personnel file with their corresponding year. So were these performance evaluations added to my personnel file prior to June 30th, 2022?
When you emailed the high school secretary on April 4th, asking for copies of your personnel file, of your personnel evaluations, they were located in the working file in Brenda Moyer's office, and they were added to your personnel file at that time.
Why did you not inform me that my performance evaluations were now part of my personnel file until June 30th?
Answered. We've had that question before.
Yep, we had one similar to that already.
Do you think that providing the school board with my performance evaluations prior to my hearing on April 20th before the board would have given the board helpful information when determining whether they should accept your recommendation to terminate my contract with the district?
No,
Why not?
because your termination was not based on performance. Your termination was based on your refusal to follow the vaccine mandate or file a religious or medical exception. It was not performance-based.
Were you concerned that providing my performance evaluations might provide positive evidence that went against your recommendation to dismiss me and the allegations you charged me with in your 20-day termination notice?
Absolutely not.
And why not?
Well, as I stated in my district termination statement, and I believe I stated it twice, and I'll go to it in just a minute and I can read it. I specifically state that I do not recommend this termination lightly, and that it is important to note that this termination is based solely on Julene Walker's refusal to comply with Permanent Administrative Order OAR 33301913030, which requires in Section 3, after October 18th, 2021, A, teachers, school staff, and volunteers may not teach, work, learn, study, assist, observe, or volunteer at a school unless they are fully vaccinated or have provided documentation of a medical or religious exception, and the exception has been approved or accepted. B, a school may not employ, contract with, or accept the volunteer services of teachers, school staff, or volunteers who are teaching, working, learning, studying, assisting, observing, or volunteering at a school unless the teachers or school staff are fully vaccinated against COVID-19 or have an approved or accepted medical exception. That is the sole basis for my recommendation for termination. It had nothing to do with your performance.
I'd like to go to Exhibit A108.
I'm also doing a quick time check here. We were rolling around to 3:30. Seeing Ms. Walker, do you got kind of a timeline? You know, you got a bunch of questions, few questions. Do we need a break, or do you think we can push through with this bit?
So I would say that I still have not even addressed, we haven't even got to neglect of duty, the charge of neglect of duty, or any cause which constitutes grounds for the revocation of such teacher's contract license, and gross neglect of duty and gross unfitness. And this is part of the reason why I was hopeful that the panel would approve my motion to direct the district to specifically state which of those 5 grounds they found to be true and substantiated, because it's making for a very lengthy hearing. As I've stated in previous emails, I knew this was going to take a lot of time, and I knew at least one more day was needed, but I hope, I don't think we're going to be able to get through the rest of my questions today. So
if I may be heard on this subject, the district has presented its case in a little more than 2 hours. The fair dismissal panel does not have to allow a hearing to go on and on and on. This teacher has had the opportunity to know the amount of time we have budgeted. Originally 1 day, extended for another day. I think that the directive can be given that she needs to complete her questioning. She can put lots of things in the brief and all that, but she needs to complete her questioning here today by 5 p.m.
Okay. I want to make sure that Ms. Walker does have a chance to ask all the questions that she does need. So I will consult with the panel. So I think at this time, we're going to take a pause in the record, and the panel and Mr. Grew and I can converse over this. And so at this time, we're going to take let's say a 10-minute break, and we will return at 3:27 after a recess with the panel and a quick break.
I will also talk to my client, because I think we may be able to provide some response to the last question that was raised about which of the grounds are the basis for this. The dismissal letter indicates that each and every one of the grounds are independently sufficient to merit the dismissal. TSPC has not made a ruling on the report that was issued, and therefore there is no determination yet by TSPC about that last portion of the letter that was written. So we may be able to shorten this up by being able to be specific about which charges we're basing this on.
Okay, thank you for that. So Sarah, can you create a breakout room for the panel? And the rest, we will be back at 3:27.
Thank you.
Do you mean 3:37?
Yes, that one, 3:37. Thank you.
You're welcome.
I think we need to go back and say that we're not relying at all on the alleged violations of TSPC.
I see Ms. Hungerford has stepped out for a second, so we may pause the record still for a second. Do you have a question? Yes. Nope, you're good? Okay, I just want to make sure everybody's back before we go back on the record.
I'm here.
Excellent. Ms. Walker, are you back there? Excellent. So we are back on the record. Ms. Hungerford, have you had a chance to talk to your client?
Yes. We would propose a stipulation that in view of the fact that the dismissal letter recommendation indicates that each of the grounds stated would be sufficient grounds for termination, that we would be prepared to have the panel make a judgment only upon whether we have proven and established 1C insubordination and 1D neglect of duty. The remaining charges relate to TSPC rules. And if necessary, I can put have the superintendent testify that the only thing that TSPC has done to this date, to our knowledge, is to ask for those records. And we are aware of no determination that they have made as to whether or not any of these have been violated. Given that, we are very satisfied to have the panel make the judgment about this dismissal based upon the grounds of insubordination and neglect of duty.
Ms. Walker, do you have a response to that?
Yes, because I have been charged with all 5 of the things, I would prefer to be able to ask all of my remaining questions. However, I will submit to whatever the panel decides to do. If the panel chooses not to allow me to ask my remaining questions, I would ask that the district be required or ordered to provide a letter, so to establish in writing that the board did not find the last 3 charges to be true.
Okay.
I think that the appropriate way that that would be worded is that the district did not defend those charges in this hearing.
And if I may, I mean, the way the panel is not, and the board is not it's not one of its duties to issue letters and clarifications or to demand or make orders of that. The way this would work out is based upon the district basically relinquishing those particular subsections in the statute. It would be reflected in whatever order the panel ends up issuing, and basically say during the hearing, the district decided it was not supporting with evidence these particular charges, in which case the panel is not proceeding or making a decision on these charges, and there's no disposition on them, which is similar or identical to saying that the district didn't prove those charges because they are withdrawing them. That's how it would work in terms, that's within the orbit of what the panel can do and not do.
Okay.
Which has the same, if not anything, more weight or value in terms of having something in the hand to show to other people or individuals or the public.
Okay. May I?
That is satisfactory for us to say that we are going forward and asking the panel to support the dismissal based upon either or insubordination and neglect of duty, and that we are not defending those remaining charges here.
Okay. Ms. Walker, did you have something to say?
Yeah, I was just going to ask if I could have just like 2 or 3 minutes to kind of think about my options here before I make a decision.
Yep, and we're gonna let you know what the panel decided at recess is that we've been with Ms. O'Mara for multiple hours, over 5 today. Many of the questions we are finding are very cumulative. They're on each other and they're answering the same thing. So we are going to put a stipulation that the direct examination of Ms. O'Mara will be complete by today, the 19th of August by 4:30. and that will allow 30 minutes for closing arguments and cross-examination by the district. Hopefully can be finished around 5 today. That's going to be the directive from the panel, that we will be done with direct examination of Ms. O'Mara today at 4:30.
If I may question about closing arguments. Many years ago, fair dismissal did not require written arguments. And I remember making closing arguments that went on for 2 hours because it was the only chance. But now, since we do provide written arguments, is there a reason why you also want oral closing?
We will allow you and Ms. Walker to choose your mode of closing arguments, but we will put a 15-minute time limit to those oral closing arguments. So you will have some time to submit a brief. 20 days. Do you believe that would be enough time to submit a brief in this case, and then those closing arguments?
So from my understanding and reading the FDAB rules, I was supposed to be notified ahead of time about a time limit on the closing arguments. And so I'm not sure if I am able to fit within that 15-minute time frame. So
those are for oral closing, and you can submit written closing as well. So you can do kind of both along with your brief.
And I have had fair dismissal panels in the past simply indicate they were going to adjourn without closing arguments orally and say, put it in your brief. But I would be glad to give a very brief closing argument. And for the two of us to stay within the 15-minute, I may have a few questions for Superintendent O'Mara, but it will be very few, I can tell you at the end.
Okay. So at this point, Ms. Walker, you asked for a few minutes to kind of gather yourself. We can pause for, let's say, 3 minutes. Is that enough time for you, or do you need 5?
Maybe 5, to be honest with you, if that's okay.
So we will return at 3:50. So 3:50 is, pause the record until 3:50.
Thank you.
All right, looks like we are all back. So we are now on the record. Ms. Walker.
So I'm going to go ahead and go with what the panel decided. Obviously, I don't think I have a choice anyways, but I'm willing to do that for sure. I'm going to jump to my neglect of duty questions.
Thank you.
Jody, are you aware that your allegation of neglect of duty is limited to evidence supported by statements in the personnel file of the teacher on the date of the notice to recommend dismissal?
No.
Can you look at your 20-day termination notice and show me what evidence supported by statements from my personnel file as of March 9th, 2022, you used to substantiate your charge of neglect of duty?
There are none.
So in terms of establishing a prima facie case for neglect of duty, did you offer any facts as to how an administrative rule promulgated by an agency that has no statutory authority to make rules concerning the conduct of teachers or grounds for their dismissal become a duty for a contract teacher?
Can you repeat the question? Sorry.
Okay. I'll just maybe rephrase it here. So in the 20-day termination notice, did you offer any facts to explain how the OHA's rule concerning the restrictions on unvaccinated teachers become a lawful duty for a contract teacher?
I don't think so, no. I mean, I stated in there that that's what the expectation is.
Is it your assertion that if you as superintendent state that something is a workplace duty, then it is a workplace duty?
Yes.
If you as superintendent were to communicate to me that all teachers must stand on their heads for 10 minutes every day at work, would standing on my head become a workplace duty for me?
I guess. I don't know why I would do that, but yes.
Okay. Do you agree that in order for a directive to become a workplace duty, there would be more involved than just the position of a superintendent as a superior at work?
What do you mean?
If it doesn't become a duty just because you, so in other words, it doesn't become a duty just because you as superintendent communicated it?
No, it has to be, it's not just because I say it. There's a reason that I say it. There's like a law or a rule or an expectation or a standard that has to be met. It's not just because I say you have to do it. There's always a reason behind it.
Okay. This written rule that you allege that I violated, was this rule written by the district?
No.
Since it did not come from the district, from whom did it come?
ODE and the governor.
So are you saying that ODE and the governor wrote the rule?
The vaccine mandate came from the governor through ODE.
Are you meaning Oregon Health Authority?
No, I'm meaning Oregon Department of Education.
So are you alleging that the Oregon Department of Education wrote the rule?
I don't know who wrote the rule. I just know it came from the governor as a mandate for schools to enforce.
Okay. So, okay. Let's see here. What criteria do you use in determining whether a written rule is a duty?
Are you referring to written rules around conduct and standards for educators, for teachers, for bus drivers, for staff?
So I'm referring to a written rule by an outside agency. So outside of the district. So Oregon Health Authority, Oregon Department of Transportation, Oregon Department of Fish and Wildlife. What are the criteria? What criteria do you use in determining whether a written rule is a duty for contract teachers?
I rely on what comes from Oregon Department of Education. So standards that come from Oregon Department of Education, rules, expectations, Division 22 standards, things like that are what are required of teachers, as well as TSPC standards.
If the Oregon Health Authority's rule is a workplace duty, what statements from my personnel file did you rely on or cite in the 20-day notice to establish that I had neglected that duty?
None.
Looking at the 20-day notice and your allegation of neglect of duty, I cannot see a single statement of fact or offer of evidence. Your conclusion that I have neglected my duty is presented in place of the statutorily required facts that would support such a conclusion. Can you point me to the evidence supported by statements in my personnel file?
There are no statements from your personnel file evidenced in the letter because it was not based on performance.
What facts would the district board rely on to substantiate the truth of your claims in the 20-day notice?
It was strictly based on your refusal to comply with ORS. Oh, I lost it. With the vaccine mandate to either be vaccinated or file a medical or religious exception, as stated in my 20-day termination letter.
In alleging to the district board that I was violating the law, wasn't it your duty to support that allegation with facts?
Yes.
Do you know the difference between a law and a rule?
Not technically.
Do you know how laws are made in Oregon?
Yes, I guess.
Do you know how Oregon administrative rules are made?
I couldn't tell you how they're made, no.
Do you know if rules can supersede laws?
I don't know.
If the district is prohibited by law from requiring a certain conduct, would it be possible for the district to make that conduct a duty for teachers?
Say that again?
So if the district is prohibited by law from requiring a certain conduct, would it be possible for the district to make that conduct a duty for teachers?
If it was against the law,
Yes.
I wouldn't think a district would make a duty if it was against the law.
Are you aware that federal and Oregon state laws prohibit employers from asking medical questions of employees?
No, I mean, I don't know. I don't know how to answer that. I don't know how to answer that question.
Okay. So just for a quick reference, so Exhibit A20 and Exhibit A21 make reference to those federal and Oregon state laws, but for the sake of time, we're just going to move on to the next question. In light of those laws, what evidence did you provide that the requirements of this written rule are not violations of federal and state law and could be made a duty for teachers?
I'm not the one who made it a duty for teachers. ODE, the governor, OHA, they made it a duty that teachers have to follow. So I didn't do that. They did. I was just tasked with enforcing it.
Okay. Could you give me one moment here to figure out where to go with my questions?
Yes.
Thank you.
Ms. Omara, is anybody else in the room with you?
No,
Okay, I thought I heard another voice, probably just internet bleed. Thank you.
no.
Okay, I guess I'll just go as far as I can go with the time that I have left. So, and then when I'm done, I guess that's it. So if you could, panel chair, if you could just kind of let me know when it's 4:30, I'd appreciate it.
Excellent. Yeah, I will make sure I do that.
Okay, thank you. All right, so I'd like to go to Exhibit A81. In your email, August 19th, you state, today the governor announced that she has directed the OHA to create a rule that all staff, workers, volunteers, and others associated with K-12 schools to be vaccinated by October 18th, or 6 weeks from the FDA approval of the vaccine, whichever is later. Superintendent O'Mara, you also state, I know this might bring some questions and uncertainty for many of you. I too am unsure what this will look like until we see the rule developed by the OHA. And end quote. Do you stand by your August 19th, 2021 reference to OAR 333-019-1030 as a rule?
Yes.
As it is used in this email, can you define what a rule is for the FDAB panel?
I don't know that there's much of a difference between a rule, a law, an OAR, and ORS, like I've said before. It's a ruling.
Okay. Okay, so if you turn the, let's see here. If you go to Exhibit A82 to the next one, the next exhibit, again, A82, and we're going to focus on the first document that's listed as an attachment. So it says 333-019-1030 on the third page. Where did you get this document again?
This document came from ODE as part of a toolkit for presenting to staff the requirements for the vaccine mandate.
So on that document, why do you think the OAR was not present in front of the 333-019-1030 number?
I have no idea.
From the title of this document, 333-019-1030, COVID-19 vaccination requirement for teachers and school staff. You say that 333-019-1030 was a mandate, a rule, and a requirement?
Do I say it was?
Yeah, would you say that that OAR is those three things, a mandate, a rule, and a requirement?
Yes.
So if you go to Exhibit A82, which is, I guess we're still in there, sorry. You go to the email part of that section at the very beginning.
Okay.
So in the subject section of this August 31st, 2021 email, you refer to OAR 333-019-1030 as a mandate by giving the email the title vaccination mandate information. Within the email text itself, you refer to the documents attached to the email as vaccination mandate information. Do you stand by your August 31st, 2021 reference to OAR 333-019-1030 as a mandate?
Yes.
Okay. Now I'd like us to go to Exhibit A86. No. Yeah. Okay, and so in that there you refer to it as a mandate 3 times again, correct? So like the title, subject title, in the body of the text, and then the attachment all use the word mandate, correct?
Yes.
So now I'd like us to go to Exhibit A11. So in that letter, your September 21st letter, attached to this email, you call OAR 333-019-1030 a mandate in the subject heading, an Oregon administrative rule in the introduction of your letter.
Wait, are you on A11?
Yes, A11.
That's not an email.
Oh, I'm sorry. It's a letter. I apologize. It's the letter, that your 21st letter.
Yes.
Okay. So you refer to it in that letter as a mandate, an Oregon administrative rule, and a requirement. Is that correct?
Yes.
So just to kind of summarize, so I don't have to ask more questions related to this particular issue, it seems that you're in these correspondences, you're referring to OAR 333-019-1030 as either a mandate, a rule, or an Oregon administrative rule. Is that correct?
Yes.
So now I'd like to go to Exhibit A7. Exhibit A7, which is the October 18th, 2021 letter. So
Yep.
in that letter, October 18th, 2021 letter, notifying me that I will no longer be paid or allowed by the district to work as of October 19th, 2021. Do you agree that you refer to the OAR again as a mandate in the text of the email and the subject heading of the letter?
Yes.
At the end of the first paragraph, you then refer to it as a law. Do you also agree that in this October 18th, 2021 letter at the end of this first paragraph that you now refer to this OAR as a law?
Yes.
In the October 18th letter, when asking me in the final paragraph to notify you by March 1st, 2022 regarding whether I intend to return for the 2022-2023 school year, you state the following. When making this decision, please keep in mind that all employees are expected to comply with all state laws, including any and all vaccine requirements. And then you again allege that I have not complied with, quote, state law in the last sentence of the last paragraph. Can you please cite the ORS number of the vaccine law with which, as you state, all employees are expected to comply?
It's an OAR.
So were you referring to OAR 333-019-1030 as a law?
Yes.
why would you in this October 18th letter stating you were placing me on what you call unpaid administrative leave, switch from calling OAR 333-019-1030 a mandate, rule, and requirement in previous correspondence to now a law in this correspondence?
All I can say is that this letter was written in consultation with legal counsel. And so those terms were used under their guidance.
Okay. So I'd like to go to Exhibit A19, which is the March 10th letter.
Okay.
So you've mentioned that you wrote this letter. Did you write this March 10th letter in consultation with legal counsel as well?
Yes.
In that letter, you referred to OAR 333-019-1030 again as a law for a total of 4 times, and then state, quote, "The district is not legally permitted to allow you to return to in-person work. Would I have been allowed to return to some other form of work, for example, teaching my classes online through a video platform?"
It actually says we are not legally permitted to allow you to return to work. It does not say in person.
I believe the OAR actually specifies that that we're not allowed to work at school.
Well, in my letter, it says you're not allowed to return to work.
Okay, so is the letter is the letter that has authority over what I'm to do, or is it the OAR that has the authority that you're drawing from to give me a workplace directive?
OAR gives me the workplace directive. I was just correcting you on what the letter said.
So despite referring to OAR 333-019-1030 as a law, you then closed your March 10th letter by referring to it again as a rule. Can you please explain why after March 1st, 2022, you are now referring to OAR 333-019-1030 more consistently as a law instead of a rule, mandate, or requirement, as you did prior to your October 18th letter?
I don't know. I really don't. Whether it was a law, a rule, a mandate, it was something I needed to follow and I needed to enforce. I guess I wasn't as particular with the verbiage I used.
So in Exhibit A77, you and the panel time to get there and myself time to get there. Are you ready?
Yes.
Was it your intention to use the term law instead of rule to justify your recommendation to the school board to terminate my employment prior to my hearing and executive session on April 20th, 2022? 2022.
The 20-day termination notice letter was written in consultation with legal counsel. And so the terminology of rule versus law was provided by legal counsel.
Do you think your reference to OAR 333-019-1030 as a law instead of a rule could have influenced the school board's decision to terminate my teaching contract with the district on April 20th, 2022?
No, I don't think many people know the difference, including myself, that I could state the difference between a rule, a law, a mandate, a standard. It's an expectation of employment.
I'm just trying to skip ahead to see which questions I'm going to ask next. So in your mind, what has more authority, a mandate, an administrative rule, a law, or a right enumerated in the Constitution?
I don't know that any of them hold a greater weight.
Are you,
I guess-
sorry, go ahead.
I guess it depends on the situation. So,
Okay. Are you, let's see here, one second. Are you familiar with the Americans with Disabilities Act of the United States Code?
I'm familiar with it. Yes.
Are you familiar with the rights guaranteed by the US Constitution?
I'm familiar with them. Yes.
Are you familiar with the rights guaranteed by the Oregon Constitution?
Yes.
And then I'm going to go to Exhibit A20, because there's some specific laws there that I just want to know if you're familiar with. So,
okay.
Exhibit A20 has a number of different laws. Are you familiar with these laws that govern the whether or not employers are able to ask employees about their private medical information?
I'm familiar with them.
And then down, the third one down, ORS 127.507. Are you familiar with the law that says capable adults may make their own healthcare decisions?
Yes.
Can you explain how the authority of Oregon Administrative Rule 333-019-1030 supersedes federal and Oregon law and the rights outlined in the US Constitution and the Oregon Constitution?
No, I'm not an attorney. I can't answer that question.
So I'd like to go to Exhibit A82. So I'd like to go, so in that is that FAQ sheet. And it's about a third of the way back. And if you look at the bottom right-hand corner, it's the document that starts numbering the pages 1 of 8, 2 of 8, and so on.
You're in Exhibit A82.
82. Yes.
You're looking at the PowerPoint.
Actually, I'm looking at the FAQs sheet.
Mhm. Okay.
And I would like to go to page 5 of that document, the FAQs sheet. So on page 5, the second paragraph from the bottom, let's see here. There's a response to the question that says, if an employee refused to get a vaccination or submit a medical or religious exception, what steps does the district take? As part of the OHA answer, it states, for employees who refuse to present proof of vaccination, medical exception, or religious exemption, the school district should follow regular procedures for corrective action, including disciplinary action. How do you interpret the phrase, follow regular procedures for corrective action, including disciplinary action?
What do you mean? How do I perceive it?
Or I'm how do you interpret it? So what do you feel like that means? That the district is required to follow regular procedures for corrective action, including disciplinary action?
I take it to mean if an employee refuses to follow whether it's a mandate, a rule, a law, an OAR, whatever, from the state, from ODE, from the district, that then disciplinary action, including up to and including dismissal, is appropriate. And so that's the action that you follow, and you follow the procedures. There's certain steps and procedures you have to go through when you're disciplining or dismissing a staff member.
Do you believe you followed the regular procedures for corrective action, including disciplinary action, in terms of my employment as a contract teacher with the district?
I believe I went beyond what I needed to do.
What statutory authority did you go to find the regular procedures for corrective action, including disciplinary action, that would guide you in dealing with me as a contract teacher for the district?
I followed due process. However, that's in collaboration with PACE pre-loss and PACE attorneys. So it's all done under the guidance of attorneys, clients, so they can help make sure that we follow all of the rules and all of the stipulations. I also make sure I'm in communication with the collective bargaining agreement union, the UNICEF president, to make sure that they are involved as well and aware of what's happening.
Did the PACE legal counsel direct you to any statutory authority where you could find the regular procedures for corrective action, including disciplinary action, that would guide you in dealing with me as a contract teacher for the district?
They provide consultation, and so they kind of guide what the steps are that we take. I don't necessarily say, give me the ORS to go look up and read it myself. That's why we have legal counsel.
Okay. On page 7 of 8 of the vaccine fact sheet, if you turn a couple pages, there's the following question. Can an employer terminate an employee for refusing to comply with the rule? Did you read the OHA response to that question?
A long time ago.
Do you remember when you read that response to the question?
Probably in August or October August when this came out.
The response to that question states the following. The employer must follow their existing personnel process in determining employee discipline issues, including termination decisions. Further, while employers may generally discipline or terminate an employee who refuses to follow workplace requirements, employers must ensure that any disciplinary action or termination does not run afoul of anti-discrimination laws. Employers may be required to reasonably accommodate individuals who are unable to comply with the law for medical reasons or for sincerely held religious beliefs, unless the accommodation would create an undue hardship to the employer or a direct threat to the employee or others. Similarly, an employer may not discipline or terminate an employee who complains about actions that the employee believes violate local, state, or federal laws. While an employer may be able to discipline or terminate an employee who refuses to comply with this rule, an employer may not discipline or terminate an employee for questioning the legality of the rule. Starting on August 31st, 2021, did you follow the district's existing personnel processes in determining employee discipline issues, including termination decisions?
Yes.
Where could I go to determine the district's existing personnel processes in determining employee discipline issues, including termination decisions?
Board policies and the collective bargaining agreement.
In your dealings with me as a contract teacher, did you ensure that any disciplinary action or termination did not run afoul of anti-discrimination laws?
I believe I did, yes.
How did you get that assurance?
Hold on, before we answer that question, Ms. Walker, I'm just going to give you like 5-minute heads up that we're getting close. So just heads up.
Okay, thank you. So how did you get that assurance that you were dealing with me as a contract teacher in a way that didn't run afoul of anti-discrimination laws?
I followed all of the expectations and process laid out by legal counsel.
Did the opinion of the legal counsel have more weight in your mind than the statutes and the collective bargaining agreement and school policy?
Well, the attorney has all of our policies for the school district. The attorney has the collective bargaining agreement. So I follow the steps that the attorney recommends I follow when it is in regards to discipline and or dismissal of a staff member.
So let's see here. On page 8 of 8, the up at the very top, there is a quote, there's a section right above the last question, and it says, finally, additional requirements may apply to employers who are subject to collective bargaining agreements or employment contracts. Did you refer to the collective bargaining agreement governing my June 15th, 2021 contract with the district regarding my employment with the district prior to October 18th, 2021?
Yes.
As stated earlier, the FAQ sheet also states employers may be required to reasonably accommodate individuals who are unable to comply with the law for medical reasons or sincerely held religious beliefs, unless the accommodation would create an undue hardship to the employer or a direct threat to the employee or others. Do you ever remember me? Oh yeah, you did ask me for accommodation, I'm imagining. Do you remember that?
What?
That I asked you for an accommodation to be able to teach remotely?
Yes, to be able to teach remotely, you did ask for that.
Do you believe that providing me with that accommodation would create an undue hardship to the district or a direct threat to me or others?
I believe it would have created an undue hardship for the district and our students.
Can you explain why you think it would create an undue hardship when the previous school year we did across the board online virtual learning the entire semester?
We had to. The year before, we had to do online learning. It was the only way we could provide opportunities for our kids to learn in the COVID pandemic. However, for the 21-22 school year, we were back full time. We are not an online school. We do not want to be an online school. It was not an accommodation that I could allow or give to one teacher, but not offer to any other teacher that wanted it. It also provided a hardship for staffing, where if a teacher is teaching remotely, but there's students on campus that are attending that class, there still has to be supervision of those students in a classroom. And if all the other classrooms are being taught in person and there's one classroom that's being taught remotely, it can cause a hardship for staffing and for scheduling of that as for supervision of students. And so for those reasons that I can remember now, those are some of the reasons that was not offered as an option, as well as that option was discussed with legal counsel and it was not encouraged.
So my question, kind of follow-up question to that. So when I was not allowed to teach on October 19th, did you not have to recreate the entire master schedule for the middle school and high school at Mapleton?
Yes, we did.
Do you believe that created an undue hardship on students and staff to be able to adjust to that entirely new schedule?
I do. However, I think that was a short-lived hardship, whereas a hardship of you teaching or someone teaching remotely would have had to have been for the whole entire year, having that schedule and having a staff member have to support that and supervise that classroom rather the whole year, rather than adjusting the schedule once and having people be adjusted to it within a week.
So would you say it was a greater hardship on the district or the students and staff to hire an additional assistant, another classified staff to monitor the room that I would be able to offer all of my Spanish and business management courses online to the students. You think that that's more of a hardship than changing the entire master schedule and requiring the staff and students to readjust to a whole new schedule?
I think it's they're both comparable, but I go back to the statement that that from the mandate that states that we are not allowed to employ, meaning I can't have a teacher work there that doesn't, or a staff member work in the district that does not have a vaccination, it is not complied with the vaccination mandate with having a vaccine or filed an exception. And I mean, so that was where legal counsel said, no, that's opening a bigger can of worms, because you really can't employ someone who is not complying with the OAR for the vaccine mandate. And so it was kind of a double there.
Okay, I know I'm at my time limit, so I will stop right there.
Okay, thank you. Ms. Hungerford, do you have any cross for Ms. O'Mara?
Yes, I do. Ms. Amara, just to confirm this point, after TSPC was notified of the dismissal of this teacher, what, if any, contact did you have from them thereafter?
The only thing I received was the subpoena for their information for Ms. Walker's personnel file and all documents related to her dismissal. That was the only communication I've ever had.
And do you know, or have you had any communication from them as to whether they have taken any action on the report that you made about her possible non-compliance with TSPC rules?
No, I haven't had any communication with them.
And in your reporting to the TSPC, do you customarily get a report back when they do take action?
To be honest, this is the first TSPC report I've ever had to make.
Okay. You were asked a lot of questions about OARs versus ORSs. I want to ask you about a particular OAR, and I think you referred to it, OAR 581-22. These are the state standards for schools.
Division 22 standards?
Yes.
Okay.
And what is your understanding of the Division 22 standards in terms of whether those are something that you have to meet?
Oh, so Division 22 standards are 22 standards that the ODE, State of Oregon, puts out that every district in the state of Oregon must be compliant in. Every year you have to report whether or not.
So I'm trying to understand why that's relevant, and especially with the time constraints that we're under.
I think that it simply contradicts its cross-examination here based upon your assertion that OARs have no impact on school districts. And so I just want to ask this witness what her understanding is in terms of possible penalties if the district does not in compliance with these OARs.
So the issue is about my duties as a teacher, as a contract teacher, and that's what the FDAB panel is about.
I know, but I'm simply asking this administrator to tell us what is the impact of an OAR from the Department of Education. This was.
We're gonna overrule that and let you ask your question.
Yeah. So a very simple question. What's your understanding of your district's obligation to comply with this OAR 581-22, and then there are subparts, but what's your understanding of your obligation?
So as a district, if we are non-compliant with any of the Division 22 standards, we have to report that in the fall of every school year. And we have to have a corrective action plan that we will put in place to become compliant. That's that school year. If we do not become compliant that school year, then the ODE, they call it sanctions, but they assign us corrective action if we do not comply the following year with that OAR, with the Division 22 standards.
if you do not comply, are there financial penalties for the district?
Yes, there can be.
Did Miss Walker ever assert to you that she had a medical condition that would qualify under ADA?
No,
Did she ever sign the exception form indicating that she had a medical reason for an exception?
no,
If she had signed that, did you have any other teachers who signed that particular exception?
we had some that signed. They were all religious exceptions. I had no medical exceptions.
Okay. Let me just ask you, your understanding, if someone had asserted the medical exception, what would they have to have established or proven or provided to the district in order for you to accept that and make accommodations?
I think that's a legal question. So I object to it.
Well, I think it's a question of procedure that this district had to face along with others, and there were specific instructions about that, but I guess we can present that in terms of legal arguments and documents that are already in the file. But let me go on to ask, did Ms. Walker ever assert that she had a religious exception and sign a request for that exception to be accommodated for?
She never signed a religious exception. No.
And you said that you had individuals who did make such an statement that they had a religious exception?
Yes.
And what did they have to do then? Do they have to submit a signed statement to that effect?
They had to fill out the religious exception form provided by OHJ, I believe it was, and turn it in to me.
And what then was your action in terms of accommodating that exception?
Once they filed the exception, we reviewed the additional safety protocols that were put in place for their certain job description and the duties that they had, and they had to agree to follow all of those additional safety protocols.
And from your memory, can you identify what were some of the additional safety precautions?
They had to, depending on their role in the district, some of them, if they were a bus driver or a van driver, they had to keep the windows down at least an inch in the front and the back of the bus. They had to double mask. They had to do weekly testing. At the beginning of the year, it was through OHA had it set up so that it could all be done through their home. So the tests were all sent to their home. And they just had to report the results weekly to me via a text message. They had to do daily screenings of their temperature and text me their daily temperature. Maintain at least 3 feet distance. For some, if they were working in small group, they had to make sure they were in a wide open space, either outside or in a gym, working in small groups with students to facilitate better airflow. Those are the ones I can remember. I could look it up if you wanted me to read them all.
No, I think that's a sufficient list. Okay. That's all the questions I have at this point in time. And I think I'm reserving the additional time I have in terms of a closing statement.
So, Ms. Walker, yeah, based on those questions that we just asked, you do have an opportunity to redirect.
So my question is, what criteria did you use to approve the religious exceptions of those that applied for it?
If a staff member applied for a religious exception, it was granted.
So did they have to make a statement of their religious beliefs on the exception form?
I believe the exception form has a place for them to, I don't have it right in front of me. I believe that it does have a space. Wait, it's right here. They had to fill out the form. It had to be on the original form. And there is a spot for the religious exception that says, please describe your religious belief and how it affects your ability to receive a COVID-19 vaccination.
Did you read those religious beliefs in order to determine whether or not to approve the exception?
I did read the statement of religious belief on all of them.
Would there have been any reason for you to not approve a religious exception?
No.
What if someone who did not have a religious belief or a medical reason that prohibited them or made them unable to do the religious exception, what if they were not comfortable with getting a vaccination, a new vaccination? They just had reservations about taking a new vaccine that hasn't been out very long, but they didn't have a religious reason or a medical reason. They just did some research and looked at the science behind the vaccine. What would they have done? What of their options, what would those have been?
They have to fill out you have to have either a medical exception, which requires a statement from a medical provider, or a religious exception where they state what their religious belief is and how it affects their ability to receive the vaccination. Those are the requirements on the exception forms.
So if someone who was a self-proclaimed atheist did not feel comfortable getting the vaccination, do you feel like they would feel pressured to lie about having a religious belief in order to avoid getting the vaccination?
I don't know. I know that I did not deny any religious exception requests.
I have no further questions.
Ms. Hungerford? Nothing, Ms. Hungerford? Okay. All right, so we're gonna move into a discussion around closing arguments. The panel decided 15 minutes kind of time limit on that moving forward.
I'd like to reserve 5 minutes of my 15 minutes for my response to opposing arguments.
Okay, Ms. Walker had a question.
Yeah, so I just want to make sure I understand correctly. Because I was not informed about a time limit prior to the start of this hearing, I'm not sure if I'll be able to get through the closing argument that I have prepared. So am I understanding that I will still be able to submit my closing argument after the hearing?
Yes, you can submit a written if you would like. Jonathan, do you want to jump in on this one?
Yes, I mean, one other possibility that exists is, and this addressing two different things, closing argument oral, closing argument written. If you feel the need to have more advanced notice, as you mentioned earlier, we would have to reschedule another time, because I know that panel members and myself have obligations pulling us away from today. So we would have to do something set up another point in time to receive closing arguments oral. We would still be seeking to limit the time for that, and that would provide enough notice for you to prepare. Alternatively, we could do a limited closing oral argument right here. Either way, it is the practice of the panel and the FDAB to offer the parties opportunities to submit written briefs, and that's the customary practice. And usually people forego oral closing arguments to provide written briefs instead.
Okay, so the closing argument is different than the brief that you're referring to.
There's an oral closing argument, there's a written closing argument. The custom is to just provide written ones and not provide an oral one. However, the panel does offer the oral closing argument usually it's one or the other. But it sounds as though Ms. Hungerford was anticipating a written closing argument, and you were anticipating an oral closing argument. So we could provide both in this forum.
Okay, would that be, so since I'm not going to be able to read my entire closing argument, could I also provide that in writing? And then would there be the brief in addition to that, or would the closing argument replace the brief afterwards?
Well, I suppose that's discretionary. I could tell you what the customary practice is. It is usually to take the closing argument, if it's in writing, and put it into a written form. And that would be acceptable and reviewed by the panel. That's usually what's done, as opposed to a closing brief in addition to a written argument, which would probably be on some level redundant. Closing brief is argument, so it is it's basically in lieu of an oral argument usually.
Okay.
Kind of what's going on here is a little unusual in that the panel's offering both oral and written.
Okay.
But normally it would just be in writing.
Okay. Well, I'll just get through. I appreciate having the opportunity to do both because I know I'm not going to be able to get through my entire closing argument. So I'll just do the best I can with the time that I have to get as far as I can in my closing argument. And then I'll also submit the closing argument in writing as well.
Okay. So Ms. Hungerford, that means you are first.
Okay, and you're allotting 15 minutes. I will use 10 minutes and then I will reserve 5 minutes of that for a responsive statement if I desire after Ms. Walker is through. First of all, I always thank panel for your participation. I know that these are times that are taken from your regular schedule. And so we do very much appreciate your intention throughout. As we've indicated, this case, the district is asserting that the appellant was dismissed for insubordination and neglect of duty. Now, there's been a whole lot of statements, questions, arguments about the difference between various rules, statutes, etc. In our brief, we will cover the fact that the Oregon legislature grants emergency powers and has done so to grant those powers to the governor. The governor was under the authority of those emergency powers at the time that she, in August of 2021, dictated that school employees would have to be vaccinated in order to keep students safe and get them back into school. That was a very important objective. She was operating in lieu of the legislature because she had emergency powers the legislature had given her. In turn, she exercised her authority to direct agencies, both the Oregon Health Authority, but primarily in this case, we're looking at the direction that was given to the Oregon Department of Education. And so once the governor's order came out in late August, the Oregon Department of Education set out to then carry out that order. And in doing so, they did create Oregon administrative rules. Those rules, though, are backed up by the legislatively delegated power that the governor had. And school districts were not at liberty to make some other decision or to go some other direction. So this district, like most districts in the state, immediately began informing their staff and letting them know what the requirements would be. Of course, because there are laws against discrimination, there were 2 exceptions that were provided. And that was again by Oregon administrative rules. There's an exception that relates to the Americans with Disabilities Act and counterpart state statutes. And that is the exception for if there's a physical condition that would prohibit the employee or make it risky for the employee to be vaccinated. And we've seen that this teacher did not ever exert or express that she had a physical limitation that would require an exemption. She never would sign a form to that effect. Why is there a form? There is a form to assert and make this a serious decision that people are accountable for if they are going to assert that kind of an exception. In addition, there's a requirement that medical opinion would have to verify that. So this is not just somebody can invent it or they have a discomfort with it or they don't like the idea of a new vaccine. Those are not covered. There has to be a doctor saying like their health would be adversely affected by having this vaccination or something comparable to that. The religious exemption also is paired up with a non-discrimination requirement against people with sincerely held religious beliefs. And so the Oregon Department of Education, as well as Oregon Health Authority, had created a basis for employees to assert that I have a religious belief that means that I cannot be vaccinated. Again, it's not just a matter that somebody makes an offhanded comment saying I have a religious exception. They have to sign a form to that effect. They have to provide an explanation of that. And when they do, It's not like they're free to interact as normal. There are reasonable accommodations that have to be met. This teacher did not ever assert a religious exception. And she was not willing to accept a number of those accommodations that were laid out by the Oregon Department of Education and this school district. One of those was that there was an opportunity, and not an opportunity, but there was a requirement to have weekly testing to determine whether or not the person should even appear on school campus, and to provide instruction to students. The choice of a district to have in-person instruction is a choice they were entitled to make. And the only exceptions that the law provides and the regulations provide is if they had one of those exceptions, a religious exception or a medical exception. This teacher had none. The district had no obligation to find some other assignment for her, place her in remote instruction or whatever. It's been explained to you by the superintendent why it was important for them. This is a high school with 6 teachers. It's important for them to have 6 teachers on the site. And if this teacher doesn't have one of those exceptions, then the district has freedom to move on and say, we want to have a teacher who will come and work on site with our students. That's the way these regulations work. The requirements in terms of due process are laid out actually by the statute. There has to be a preliminary statement of the reasons for termination. There has to be an opportunity for a hearing before the board so that there is a response and the teacher can make a case before the board. And there has to be action by the school board itself. But the other due process protection is this process we have right here in fair dismissal. It is the post-termination hearing to insist and ensure that teachers have due process. The district met all of those requirements. Now, regarding the 2 categories, insubordination, I told you at the beginning, it's been defined as disobedience of a direct order or an unwillingness to submit to authority. But there have been cases that have determined that those are 2 sort of possibilities. In other words, it doesn't have to be shown that there is defiance, a defiant intent. Where there is a direct order given, and that is clearly given, and the teacher says, I will not comply with that, that is insubordination under the law. And that is exactly what happened here. I think that this superintendent went far beyond what happened in many districts in terms of her conversations with Ms. Walker, opportunities for Ms. Walker to mull this over, to discuss it, and the very act of placing her on unpaid leave instead of terminating her so that there might be a change in the rules, the governor's requirements, and that she would not eventually lose her job. That did not happen, but I think it speaks to the good intent of the district that they placed her on that status as opposed to moving immediately to termination, which they had a right to do. So it doesn't require a defiant intent. It requires a clear directive and failure to comply. And that is exactly what we have here. Neglect of duty means a failure to engage in conduct designed to result in the proper performance of duty. And in reality, in this particular situation, those are very close together. It means the neglect of the teacher to the school district and the students, which can occur through repeated failures to perform duties of a relatively minor importance, or a single instance of a failure to perform a critical duty. In this case, this was a single instance because never prior to the deadline, even prior to March 1st of 2022, this teacher never would perform the duty that she had under the governor's order and under the ODE rules that were established and mandated for school districts to follow. She would never sign an exception. She would never get vaccinated. Those were the 2 options. They were the only 2 options. And she would not perform that. In doing so, she did neglect her duty to the district. she had a duty to make herself and keep herself employable and to keep herself in a position where she could perform the job she was required to do, which was to provide instruction to students. So for those reasons, we believe that the district's case has been established here, that this indeed was a violation of both of those. But as we've stated, and the board stated at the time, either one of those could be a sufficient reason that they would have dismissed for. And with that, I'm going to end my statement, but I will reserve 5 minutes for a response. Thank you.
Thank you. So Ms. Walker? You're muted still.
Thank you. I'm going to set a timer, but if you could also just maybe, would you mind giving me a two-minute warning, or actually how about a 1 minute warning?
Yes, I will.
Thank you. You have heard extensive testimony. This case is very large because the district board voted to dismiss me by agreeing with each of the grounds recommended in the 20-day termination notice. I was left with no choice but to address each one individually with each witness, with the exception, obviously, of what the decision that was made today to, as the district has suggested, basically throw out the last 3 charges. The issues are many, but can be summed up into 4 broad categories. Although the burden of proof is not on me, I hope that you will find that I have proven that none of the allegations against me are true or substantiated. The first category is a jurisdictional one. The second issue is whether the district acted fairly in terminating me by following the lawful statutory process, or whether I was unlawfully terminated. The next issue, issue number 3, is the insufficiency of the 20-day termination notice pursuant to ORS 342.865 grounds for dismissal or non-extension of the contract teacher. The final issue is the failure of the district to present evidence to support the allegations of my conduct to substantiate how the alleged conduct fit the elements of the alleged grounds for dismissal. So relating to the first category, jurisdictional unfairness. The Administrative Procedures Act, ORS, Chapter 183, describes the law concerning how the agencies of the state of Oregon shall make rules and how persons affected by the rules can have their cases heard in contested case hearings. The Oregon Health Authority has generated a rule which impacts teachers, but the OHA has directed the rule to be implemented by local school district boards. The enforcement actions of the OHA described in OAR 333-019-1030 are directed not at teachers, but at districts. The rule says that districts cannot employ teachers who do not present proof of vaccination or apply for a medical or religious exception. Further, the rule threatens punishment, not of teachers, but of districts who do not comply. By punishing districts, but not teachers, teachers have no recourse at all against the OHA and no right to a contested case hearing, even though teachers bear the direct force and consequences of district actions flowing from the coercive rule of the OHA. So after being dismissed from my teaching position by the district based solely on my alleged non-compliance with the rule of the OHA, I can only appeal my dismissal to the Fair Dismissal Appeals Board, who is given no statutory jurisdiction to judge the administrative rules of the OHA. I must defend myself against the ground of dismissal found outside of ORS Chapter 342, but I may only rely on facts of grounds for dismissal found inside of ORS Chapter 342. In other words, I'm being asked to play a game of basketball, but I have to follow the rules of soccer. My hands are tied. This is fundamentally and foundationally unfair. In her testament, or in her statement to the district board in support of her recommendation to dismiss me, Superintendent O'Mara said the following: "It is important to note that this termination is based solely on Julene Walker's refusal to comply with Permanent Administrative Order OAR 333-019-1030. This was a dismissal in search for statutory grounds. This alleged non-compliance had to be linked one way or another to statutory grounds for dismissal found in ORS Chapter 342. In doing that, great damage was done to the entire process laid out in the chapter, all because the OHA became an interloper, inserting its own grounds for dismissal and literally demanding dismissal where the law had given exclusive authority to the enumerated grounds and to the discretion of local district boards to apply them when and if they chose to do so. Prior to the promulgation of the OHA rule, I was working hard as a Mapleton teacher. I had developed a reputation for being a competent and ethical educator. The constantly changing protocols driven by a public health crisis were creating continual challenges that I was facing daily. Before the time of COVID and during the time of COVID, I was known for being proactive, resourceful, trusted, respectful, caring, skilled, and willing, and cooperative. You have heard testimony from my direct supervisor that she never had any issues with me being insubordinate, neglectful of my duties, or engaging in conduct that could remotely threaten my ability to my teaching license. I was actively engaged in bettering myself professionally for the benefit of myself, my colleagues, the students of the district, and the entire community. I was by no means perfect, but I was conscientious and careful, knowing that I could be seen as a role model to younger students and younger teachers. In other words, I was minding my own business in tiny little Mapleton with the respect of others in the district and in my community. No one gave any thought to the idea of firing me. No one gave any thought to connecting my employment with the district to my private medical choices or my private religious convictions. I felt safe in my employment, knowing I was performing all of the duties placed upon me by my contract, district policies, the teaching standards and practices, and the laws of Oregon. I felt safe in my employment, knowing that I had not been neglected in any conduct, or I had not engaged in any conduct which would substantiate any of the grounds for dismissal listed in ORS 342.850. I felt safe knowing that the collective bargaining agreement and the process for dismissal in ORS Chapter 342 protected me from arbitrary actions and from being suspended without pay. I felt safe knowing that I would not be fired unless I engaged in bad conduct and was given a fair process to establish that I was deserving of such severe discipline. No one could be more surprised than I to find myself before this panel fighting to save my job, a job I have spent years training for, a job that serves a critical role in my community, a job that I have performed with integrity. One day, I'm a teacher in good standing with no blots against my record, and the next day I'm accused of being insubordinate, neglectful of my duties, unethical as an educator, and in danger of losing my teaching license. Without any change in my conduct at all. I stood still, but the rules around me changed. What was once perfectly acceptable and private became not only unacceptable, but was labeled as unethical and possibly unlawful. And private matters became matters of public record. In the evidence I have presented, I believe the panel will find that the district's predetermined dismissal and their search of grounds to justify that dismissal to be fundamentally unfair. This is a critical issue over which the Fair Dismissal Appeals Board does have jurisdiction. Now, with regards to the second issue relating to the district's failure to follow the statutory process of dismissal, which ultimately led to an unlawful de facto termination. You heard Superintendent O'Mara testify that I was unilaterally prevented from working and that all of my pay and allowances were stopped on October 19th, 2021. The district has called this action a quote, unpaid administrative leave. In spite of this label, no law, rule, district policy, or even contract term makes provision for any such unpaid administrative leave. Additionally, all leave policies enacted by the district are defined by requests from the teacher to be absent from work. Superintendent O'Mara testified that I never requested a leave of absence. What happened to me on October 19th, 2021 was a suspension. Calling it something else does not make it something else. The legislature seems to have anticipated that districts might suspend teachers and hold them in limbo indefinitely without pay, and they enacted ORS 342.875 into Oregon law. This law prohibits suspensions lasting longer than 5 days without a recommendation for dismissal. This law requires that at least the first 5 days of a suspension to be with pay. Further, the Oregon law requires that if no process for dismissal is begun within 5 days, the contract teacher must be reinstated. The district violated the statute. It could not be more clear that Superintendent O'Mara suspended me. A suspension may, by any other name, is still a suspension. If what was done to me does not match the definition of a suspension, then nothing does. Even if the FDAB finds the grounds for dismissal were true and substantiated, that would not undo this statutory violation. At the very least, the FDAB should find that I should have been reinstated no later than October 25th, 2021, and that I should have been paid for those 5 days of suspension and every day until I was dismissed. After October 19th, 2021, my employment status was undefined. The superintendent has testified that I was on leave but still employed. But between October 19th, 2021 and my dismissal on April 21st, 2022, the district treated me as a stranger to the district, not as a teacher employed under contract. If I had been lawfully suspended on October 19th, 2021, the district's lawful actions to dismiss me would have been complete within 2 months. A 20-day termination recommendation followed by a decision by the district board at the first regular board meeting after the expiration of the 20 days. I would then have had recourse to file an appeal with the FDAB. Instead, I was assigned the nebulous status of unpaid administrative leave because that status has no legal or policy-based definition. It does not come with a process for an appeal. I wasn't even told if I was being disciplined or punished or anything. I don't want to keep repeating the word limbo, but my vocabulary fails me. I was neither being treated as a teacher whose employment is governed by strict contractual terms, nor was I lawfully dismissed so that I could move on in a statutorily governed appeal process. I tried to go through the grievance process that is available to teachers. As soon as I realized that I was being treated in an unlawful way that violated the contract and the collective bargaining agreement, which would have been, that was the last week of February when I was preparing my March 1st letter to give to Superintendent O'Mara. So I tried to go through that grievance process that is available to teachers, but that was denied to me by the district. Perhaps if I had not filed the grievance, the district would have continued the so-called unpaid administrative leave indefinitely without dismissing me. The Superintendent O'Mara has testified that she believed she was under no obligation to begin a process of dismissal or to reinstate me. What was I supposed to do in this situation? This is precisely the circumstance that ORS 342.875 prohibits, a de facto termination with no avenue for appeal. Because the district was in complete breach of contract and was not performing a single one of its contractual duties towards me, I was under no obligation to attend a pre-termination hearing with Superintendent O'Mara. And after months of no action on my employment and no contract and no contact from the district, and then the apparent retaliatory response to my grievances, I was afraid to attend that meeting without legal representation. Over the course of this hearing, I have heard testimony that was shocking to me. While I was aware of most of the basic facts of what has been done to me, a clearer and clearer picture has come into focus of the implications of those actions. We have heard testimony from Mapleton school board members who viewed my dismissal as a done deal before it ever came to them for a vote. We heard testimony that board members had no knowledge of or care for the statutory lawful duties and their statutory lawful duties and responsibilities.
I'm going to interject that the 15 minutes has expired.
I think I have one more minute, actually.
She has about 1 more minute left.
Okay.
They continually deferred to the will and judgment of the superintendent or legal counsel, who have no statutory authority to dismiss contract teachers. And because the superintendent and the attorneys are not elected to public office, they are not held accountable for telling the board they must vote to dismiss. We heard from the superintendent that there was no controlling legal or contractual authority that could prevent her from telling me to go home and never come back to work. Aside from the actual expiration of my contract's term, she believed she could keep me on unpaid leave indefinitely without work and without pay, and I had no recourse at all. I had exactly the same recourse as a stranger off the street asking to be reinstated as a teacher. I was being treated as a non-employee. So basically, if a truck driver gets sent home by his boss, told not to come back, and is given his final pay, no one would question whether he had been fired. But when the same thing happened to me, a public school teacher, I wasn't actually fired because no one used that word, or because the superintendent had not yet bothered to get the rubber stamp from the district board. A complete lack of performance of contractual duties creates a presumption that a contract had been terminated. And I know I'm out of time, so I'm going to go ahead and end right there.
Thank you. Ms. Hungerford.
Yes, let me just make a few remarks here. First, this was a situation that has never really been visited before upon the state of Oregon. But I would like to read to you the statement of the governor in late August. Quote, "Our kids need to be in the classroom full-time, 5 days a week, and we have to do everything we can to make that happen. While we are still learning about the Delta variant, we know that previous experience that when schools open with safety measures in place, the risk of transmission is low. That is why I have directed the Oregon Health Authority to issue a rule requiring all teachers, educators, support staff, and volunteers, K-12 schools, to be fully vaccinated. The governor's authority came from the legislature. She has emergency powers at this point. She directs OHA to establish this rule. And specifically, it's very specific, the rule that she's asked to establish. And she directs the Oregon Department of Education to make sure that school districts follow this rule. This is not a case where school districts had any choice. They did not have a choice in terms of having teachers vaccinated, and there were only 2 exceptions which were provided. This teacher refused to use either of those exceptions. She is in direct violation of rules that are established by the authority of the governor. It's a very simple case because she's never asserted that she ever intended to take one of those exceptions or that she actually did make any move to do so. It's very clear that she had no intention to. They were given many opportunities. Without taking one of those exceptions, the school district was not entitled to continue to employ her. And they were not entitled to put her in contact with students. And because of that, they had to act. Now, to turn the superintendent's charitable belief that there might be a change and might be allowed this educator a chance to change her mind or the rules to change, I think that you should view as being going above and beyond in terms of her duty and obligation. So given that, the fact that they waited that additional period of time, nevertheless, they were not entitled to employ this teacher to provide any services during that period of time. The evidence here is quite clear. It's not contested even. She did not take one of the exceptions. She did not get vaccinated. And under the governor's order, she was not entitled to teach, and the school district was not entitled to employ her and pay her and put her in front of children. The school district was not obligated to run remote instruction because of a teacher who would not take an exception. For that reason, the school district was left at no choice but to terminate her employment. And I will cover other issues in the written brief. Thank you.
Thank you. Okay, so at this point, we are going to move to close the evidentiary. I do need to ask, are there any other matters to come before the panel at this time? Ms. Walker.
When would the panel like to receive the written copy, the full written copy of my closing argument and the written brief?
So I threw out 20 days. I don't know if you guys need more time than that.
I do.
Customarily, it's about 30 days. I think that would probably stick us right in the end or middle of September, middle to end.
That is the earliest I possibly can do so.
Okay.
I do have a Court of Appeals brief that is due in the middle of September. I have an arbitration brief that is due at the end of this month, and a unfair labor practice case brief due the first week in September. And I have one additional case before fair dismissal that has been scheduled for September 30th.
Okay.
I will make.
Cameron, this is Sarah. May
Sarah.
I make a suggestion? 30 business days is September 30th. Can we accept it on October 3rd?
That would be acceptable, yes.
October 3rd is a Monday, so that would give you guys hopefully enough time.
It's technically 30 plus 3 days, 30 business days plus the weekend.
Okay, thank you.
Does that work for you, Ms. Walker?
Yes, and is that for both the closing argument and the brief are both due on October 3rd, correct?
Correct. Both would be due on that day.
I assume that you want us to combine our closing argument with, yeah, okay. One written submission, right?
Yes.
Thank you.
Okay. So very well, this yes.
Sorry. I know in the I think it was referenced in the pre-hearing conference and in the rules, it talks about submitting a proposed finding of facts. Is that also something that this panel is requesting as a proposed finding of facts to be submitted by that date as well?
So that would be integrated into the closing brief, proposed findings of fact that you believe the panel should find in support of the conclusion in your favor.
Okay, thank you.
Okay. So with that, the evidentiary hearing is now closed. Thank you to the panel and everybody who helped make this happen. The panel, if you guys could hang out for a little bit.